Any mention?
Please, Your Lordship. Lordship, I beg to mention item 7.
Yes. What's the matter about?
This is
Regarding appointment, Your Lordship.
appointment.
It was heard.
No, Lordship.
Oh. Yes.
I have no objection, Your Lordship.
Okay, it's 2 weeks.
Apply, Your Lordship.
Item number 1.
Yes. 1 second.
Hello, this is a review petition we have filed against my lord's judgment of 2nd of June 26 on the Jorbat GST matter.
Yes.
My lord, with greatest respect, I may say that there are few inadvertent errors that have crept in which calls for a review.
You argue within the 3 parameters. Where's the miscarriage of justice? Where's the
Yes, my lord.
error apparent? What new materials have you brought? Yes.
Yes,
Make
my
it
lord.
short within 5 minutes, Mr. Ghosh. Yes.
Yes, my lord.
Yeah.
Kindly have page 13 of my review petition, the first
13?
ground itself.
Yes.
Page 13. Yes.
30.
1-3.
Yes.
I'll first explain the error and then take myself, my lord, to that.
Yeah.
Para A, 13.
Yes.
Page 13, para A. For that, the error apparent on the face of the record has crept in at para 47 of the judgment under review, in as much as inadvertently, decisions which were in fact in favor of the petitioner have been applied against it in non-suiting the petitioner on grounds of alternate remedy. These decisions being that of the Allahabad High Court in the case of Indo-Gulf Fertilizer and Chemicals, etc., etc. I'll explain that, my lord.
No,
If
please,
I
Mr.
come
Ghosh,
to-
please listen. The thing is that now these judgments which we have to use is not on a ground of alternate remedy. This Indo-Gulf also is called positive value on alternate remedy, but on the ground where a circular will be binding on a quasi-judicial tribunals or tribunals.
Yes, my lord. I will.
So it's on that limited ground. So we're not accepting argument on this point. Number 1, with
Absolutely.
regard to seeing alternate remedy. Next argument, yes.
Yes, my lord. Let
Next,
me show,
next,
let me
next.
show
Yes,
the
please, next.
judgment. Yes. If my lord,
We won't go to the judgment, please. No, please go to the next ground.
my
Yes.
lord, the judgment is very important because.
Please go to the next ground. We have seen a judgment. Mr. Ghosh, we've seen a judgment. If our judgment is replete with errors, go for appeal. Why are you coming back for review?
Yes,
Don't make this into a guise on an appeal, Mr. Ghosh.
No, absolutely not. In fact,
That's our
I'm going to place
observation.
judgments. I'm going to place judgment before my lords, where their lordships have said that if a judgment, if there is an inadvertent error on the part of the
Yes,
court,
Mr. Mojika.
para 15.
One second.
Para 15.
The scope of review, my lord, is well settled now.
My lord, kindly see para 15. Kindly see para 15 of the judgment of Indo-Gulf. It is in my favor. Kindly
Yes,
see.
we know it's in your favor. We've seen the judgment, but the only positive value is not of our High Court, Mr. Ghosh.
My lords have relied
Then
upon
then-
that. My lords have relied upon that.
Relied upon
My lords have relied
only
upon
one point with regarding the it's got positive value with regard to circulars, whether it be binding or not.
Yes, and in that
You
judgment.
don't stretch the agenda. We're giving you enough indulgence.
Judgment, my lord, that judgment itself says that if there is a circular binding, appeal is a futile exercise. Kindly see for a minute. Page.
That is why it says
728.
circulars are not binding. They're not binding. That's a finding in the yes.
Very, very.
No, I don't argue the counsel, Mr. Ghosh.
Yes, very-
But your reputation, prima facie, has not made out anything for us to even remotely like a high court, the court of record. We have enough power of review. The thing is that if the error apparent is patently like in the face of the record, if you bring in some new materials, we can understand. If it's on a point of law, sorry, on a point of misapprehension of judgment, sorry.
For a minute, if my lord allows me 5 seconds, I'll try and explain.
Yes.
In Indo-Gulf at para 15, their lordships have said, I read it. It has then been submitted that the petitioner could have moved the Commissioner of Income Tax under 260 of the Act in revision. In this connection, it has been clearly pointed out by the learned counsel for the petitioner that in view of the stand taken by the opposite party that the circulars and decisions issued by the board bind the department authorities, it will be of no use to approach the Commissioner in Income Tax. This very same judgment that my lords have applied against me is exactly saying that appeal is a futile exercise. So therefore, my lords have taken cognizance of para 11, but para 15 my lords have inadvertently missed out. And what we had relied upon was a constitution bench judgment. What we had relied upon was a constitution bench judgment, if my lord will see.
See, Mr. Ghosh, the reliance of judgment on this Indo-Val is on a separate context altogether. It's regard about the binding nature of circulars, which you say that appeal futile because the circulars are binding on all the appellate authorities down the line. And with the other point regarding jurisdiction, we said proper officers to show that there's no lack of jurisdiction on the part. So you are free to go to 107.
So far as proper officer concerned, I have not even agitated the point now. I'm only on the alternate remedy because in that judgment, in Mallard's paragraph, para 37, Mallards have said that it is binding on, it is not binding on court and tribunal. Yes. It is binding on department authorities. My appeal is before the department authorities, not before the tribunal, not before the court. So therefore, even that judgment, ignoring para 15, that judgment itself is in my favor that it is binding on the department authorities. Section 107 takes me to department authority.
1 second. Yes, Mr. Ghosh, reviews on appeal this guy. If we misapplied the judgment, we are sorry that you have recourse to appeal. You heard Mr. S. Goel and counsel the petitioner. Mr. Dr. M. accept notice on behalf of their counsel.
May I submit some more, my lord? May I submit some more? It is also well established that when my pleadings are not considered, my prayers are not considered, there is an error apparent. For a minute, if my lord comes to my...
Mr. Ghosh, you are argued for around, I think we gave you enough indulgence, and your submitted rejoinder submissions were running to hundreds of pages.
Well, my
sorry if incompetent to your satisfaction.
No, I don't say that. Yes. I am only saying it is an inadvertent error. My
rejoinder heard Mr. S. Ghosh and Senate Counsel, assisted by so-and-so, Dr. N. Mozika, I with M. Chiang, is present on behalf of respondent number 1, 3, 1. No, not 1, not 2, 1. 1, 3 and 1, 3, 5. 1, 3, 4, 5, 6. 1, 3, 4, 5, 6. 1, 3, 4, and 5. Miss Eng Sing Khan.
2 and 7.
Is present. We have 2 and 7. This is an application for review of judgment order dated 2/6/2026. Part honorable by this court and LPC number 245/2024. The grounds are set out in the review application are basically on a misinterpretation of a judgment which has been detailed in ground A of the review application. Further ground setup is that certain prayers and substantive contentions and pleadings have not been dealt with, and that the judgment of this court has caused grave prejudice to the review petitioner. As such, reviews paid. Ms. S. Ghosh has also argued the matter on the matter of applicability of judgments or misinterpretation. On a detailed it appears on a bare perusal of the review application that none of the 3 standards for review have been met in the application, as much as the petition the review has recourse to appeal. So accordingly, a review option is not entertained, the same dismissed. Yes.
My lord, may I seek an indulgence, my lord? My lord, they have given me 4 weeks time to file an appeal. My lord, they have given me...
Dismiss, Mr. Ghosh. You should go and file an appeal.
I'm only seeking another 4 weeks can be given to file the appeal.
Cannot, my lord. They have got enough opportunity.
Another 4 weeks may be given to file the appeal, my lord. I'm only seeking that indulgence.
That you can, we have pursued the review here. You can make that thing before the...
My lord, may put that line in the order.
Thank you.
My lord, may put that line.
No, Mr. Ghosh, sorry. Enough indulgence, yes.
Item number 2.
Grateful.
This is my application. Item 2 and 3 are for the same petitioner, just different periods. This is a case wherein I had done a HVAC work for Northeastern Indira Gandhi National Hospital, and that was regarding installation of HVAC and ACs. Lordship,
HVAC, what's HVAC?
Lordship, it was a centralized air conditioning system for the entire hospital. No, Lordships, under the GST law, because my output tax was payable at 12% and my purchases, which I had procured various raw material, that was at 18 and 28%. So the law has provided under section 54 a refund mechanism under the heading called inverted duty structure. IDS we call it, Lordships, wherein the output tax is less and the input tax is higher. The government has planned a scheme. And in that scheme, the government has notified certain exclusions. Okay, even if you are under IDS, you will not be allowed to claim a refund. That particular exclusion is for, under the notification 15/17, was for construction of immovable property. So say I am a developer, the person who is developing that hospital, if he has any input tax excess, he cannot claim. But my service was a pure works contract service. So basis the notifications prevalent at that time, we filed a refund application under the law in 2021 for the financial year 18-19, which is first serial number. Lordship, under section 54 of the statute, CGST Act, the law has prescribed a detailed mechanism of how to deal with a refund application. It is stage by stage. I file an application. If they find any deficiency, they issue a deficiency memo or they issue me an acknowledgement. And they have to complete the entire process of refund, either accept or reject within 60 days, which is mandatory, and the terminology used under the provisions is shall. The refund shall be processed or rejected within that period of 60 days. In the facts of the current case, Lordships, 28th of July 21, I filed my refund application. They acknowledged it on 20th of August 2021. After 1 month, as per law, it should be done within 15 days. They did it after 1 month. That is also fine, Lordships. Now, Lordships, they issued me a show cause notice on 20th of October 2021 after the expiry of 60 days. And that show cause also was only a summary show cause without any allegation, just one line. Not eligible, just a single line. We visited the department and we filed certain responses. They rejected my application in 2024. 5th of August 2024, they rejected my application again without any personal hearing, nothing. We carried that application before the appellate authority under 107. The appellate authority, Lordships, held yes, there is a violation by the proper officer. He has not granted any detailed show cause. He has not granted any personal hearing. So he says the refund process has been vitiated. So this has to be remanded back. Lordship, under section 107(11) debars the appellate authority to pass a remand order. 107(11) of the Act, Lordship, I brought the compilation, which it says that the appellate authority has to decide on merits. There is no power in the statute given to the appellate authority to remand. But appellate authority in this case remands. And he agrees, yes, the entire process has been vitiated. Now, after remand, Lordships, the proper officer again issues me a show cause notice and again rejects my application on totally incorrect reading of the law. So, Lordship, I am before today, your Lords, on three major issues. First, Lordships, whether the 60 days period under section 54(7) is mandatory or not. Second,
your works contract is covered.
Lordships,
It is covered.
Lordship, it is not works contract.
Schedule. Yes.
Works contract, Lordships, schedule 2 has a separate classification for works contract.
When we examine that, you accept notice.
Yes, my lord, I also have a objection with regard to the maintainability. That's why
That you can put it
I'll just
on
take a
a
minute, my lord,
objection.
just to
Yes.
point out. Yes, I'll file an affidavit, just see what's under challenge, my lord. The first application was rejected in 2024. They preferred an appeal and the appeal was allowed. Please see the order of the appeal, which is at page 61. I'll just take a minute, my lord. Page 61.
Yes.
Let's have it. 9th June 2025. This is the order of the Commissioner of Appeal. Well, it's the
61,
operative part.
61 is.
So I believe there are two. Mine are not numbered.
Go to the other petition. Yes.
Perhaps. That will be page 71, my lord. In that case, page 71, and the operative part is at page 74.
Yes.
And please see the 4th paragraph at page 74.
Yes.
May I just read, my lord? Given the above lapses, it would be inappropriate at this stage for the authority to examine the merits of the refund claim. The procedural infirmities, that is the denial of the hearing and the inordinate delay, have vitiated the adjudication process, thereby necessitating a de novo consideration of the claim. Accordingly, in light of the circumstances highlighted above, the refund application may be refiled by the applicant within 15 days from the date of this order and shall be processed on merits in accordance with law after granting a reasonable opportunity of hearing. It is further directed that the refund authority shall process the refund claim afresh, treating the original application as validly filed and received, and shall not invoke the limitation period under so and so. So therefore, there was an order directing them to refile the application. What they did, now their contention is that the authority under 107 cannot issue an order of remand. Against this order, which was passed in 9 June 2025, they actually go back voluntarily to the same authority.
Exactly, we see that. It's right here.
Yes, and that gets rejected. I'll just explain.
No, Lordship, I will explain, Lordship. Once fine, let me try and
approbate and reprobate the
I will,
jurisdiction. Now, please see what their prayer is. So they go back before the original authority,
right,
and this time again suffer a rejection. Now, please see the prayer at page 28. What are they really challenging? Now, let's the first order of rejection, which was passed in 2024, is also under challenge here. That does not exist. That has already been set aside.
Yes, you have.
Then they challenge the appellate order.
Ankit Kanodia.
Yes, you take notice. You file objection. Yes, heard Mr. A. Kanodia. You alone.
No, Purnima Roy is local advocate on records.
So yes, issue notice. Mr. S. Sen. Yes, plan on all respondents.
My lord.
All respondents required just after 3 weeks for affidavits. Yes.
Grateful.
Similar order in other case.
Lordship, same order. For item 3. Grateful.
4.
On this matter, this is the Kanpur GST matter.
We'll close it, Mr. Paul.
They have to go and file.
I am staying for a small accommodation today, Millet. Your Lordship may have it anytime next week.
What kind of instructions are you waiting for?
Millet, I'll have to try and satisfy your Lordship's Millet that because we paid only under protest, Millet. We've paid only under protest. So the subject matter
that is fine. We get exited before the appellate authority.
You have enough. There's enough scope and latitude for you to agitate for the appellate tribunal.
I'm a little handicapped today. Your Lordship will have it on Tuesday next week, Millet. I think there'll be no prejudice to the respondents. Next week, Tuesday, Millet.
We are mind to close this matter. Yes. On the prayer of Mr. K. Policy and Counsel due to personal difficulty, list this matter after we listed on 23rd.
23rd, that's very well.
Yes.
Please, we won't be so sleep deprived. Yes.
Well, the blame goes to the game.
Absolutely.
Hearing. 5.
Malaj, this is the teachers' matter, Malaj. We had made our submissions. The Learned Advocate General is to respond.
Please, Your Lordship. Lordship, the Learned Advocate General, he's on next, my lord.
Wait, in Shillong?
Lordship, in court 1.
What are we to do?
My lord, can come after in the boat, my lord.
We already at the end of the board.
In fact, my lord, I have these compilations of judgments, my lord. If I can supply
You want
today.
us to look at them meanwhile?
No, my lord, it can come after 2 weeks, my lord. In the meantime, I just supply the compilation in advance.
We'll have it on 23rd. You give the compilation to MSR Datta.
Malaj, there is a little urgency in this matter.
We understand.
Your Lordship should recollect. Your Lordship have noted it on the last order that status quo should be maintained with regard to
Yes.
that was my submission.
Yes.
What the government has now done is, Malaj, they have issued some directions, basically forcing the teachers, Malaj, to come under the new scheme. My friend Miss Datta can just place it before for my Lord's consideration. So this notification has been issued after the last date of hearing, Malaj.
5 and 8.
So if they can't take it up today, Malaj, may I pray your Lordships take up the matter on Tuesday next, Malaj?
Tuesday will be difficult. That's 21st, right? Oh no, it'll be. Now we on. It's 14th. We can do it. It's 14th, okay. Yes.
14th, Malaj. Where?
Due to unavailability of the Advocate General, this is matter on 14th July. Stop. Mr. James Nanja also raised that he be permitted to
I've supplied.
to advance copies of the judgment to be relied upon. Various allowed list on 13th, yes, or 14th. Yeah.
Advisory.
I'll reply.
Any mention?
May it please, Your Lordship? Your Lordship, I beg to make a mention of item number 84, Your Lordship.
Yes.
Lordship, I'm praying for 1 week's time, Your Lordship.
No objection, Your Lordship.
Yes.
Highly obliged.
Highly obliged.
Please, Lordship, I beg to mention item number 77.
Yes.
Since the continuation is on leave, let it come after 2 weeks, Lordship.
No objection, Your Lordship.
Yes, Lordship.
He's not on leave. Yes. Okay. Yes.
Highly obliged.
Your Lordship, I beg to mention item number 81, Your Lordship.
It's what matter is this?
This is land acquisition, Your Lordship.
Land acquisition.
Yes, Lordship.
Okay, 2 weeks. Yes.
Lordship, I beg to make a mention for item 76, Your Lordship. 76 and 83, Your Lordship, 2 more.
I can't hear.
76, Your Lordship.
76.
That's freezing account.
What's it for today?
It's for hearing.
To examine the
report, status report. Lordship, I fix tomorrow, Your Lordship.
Why?
As it's instructed by Senior Counsel. This is tomorrow, Your Lordship. It's not available today, Lordship.
Tomorrow?
Yes, Lordship. Fix it tomorrow, Your Lordship.
Difficult. Huh?
Subject,
You're
Your
there.
Lordship.
Who's there? Where's Mr. Thapa? He's the. Yes, Mr. Thapa. You're well versed in this matter, correct?
No, my lord. I'm aware of the matter, my lord, but I'm not.
You're not?
No, my lord, I'm not really tagged with this matter. My other colleague is my lord, supposed to appear in this
Who's
case.
other colleague?
Miss Rakhi, my lord.
She was here just now.
We can have it tomorrow, my lord. I'll just go through the report once.
Only we can come with the Chanda, MS Cruz, MS Datta, all of you. Yes.
This is the report.
So when will we have it? We're going to close this matter.
We can have it day after, my lord, on Friday. Subject to your lordship.
Day after is a holiday.
Sorry, on Friday, my lord.
Not on Friday.
Have next week.
We'll have it next week then.
Yes.
But please don't adjourn it anymore.
My lord.
Otherwise, after 1 week.
Gotcha.
Where is the report? The prayer report is Thapa.
Item 83 as well, Lordship. Similar prayer for item 83.
83.
Lordship.
What other side? Mr. Khan.
Sino Conry, Lordship.
Yes, you're there.
My lord.
Yes.
Obliged.
Yes.
Your Lordship, I beg to mention number 82, Your Lordship.
Oh, yes.
No objection, my lord. No objection.
Yes. Make it quick if they are joining, yes.
I beg to mention item number 79, Your Lordship.
79.
Yes.
Nongjarong village. Where other side who's there? Nobody is there. You've taken consent. And then you take consent, yes. Yes.
Please, Your Lordship. Lordship, I beg to mention item number 75, my lord.
You've informed the other side?
Lordship.
No objection, Your Lordship.
Yes, okay.
Obliged, my lord.
May it please your lordship, I beg to mention item number 72. I'm for respondent number 4 and 8. Your lordship, I pray for 2 weeks time as my learned seniors on sanction.
There is urgency in this case, and more so, my lord, they were supposed to file affidavit, they have not filed, my lord.
Who's supposed to file affidavit?
They said they'll be filing additional affidavit.
Number 4 and 8, you are?
For Roy Kumar Sundram. Learned.
He's not the respondent, he's a counsel. He's counsel, 4 and 4 is who? Is the village or is the headman?
Yeah, Mintri.
Mintri.
Yes, my lord.
Lord, let it be a last opportunity, my lord.
No. When you take adjournment, you don't allow this. Yes, after 1 week, right?
Obliged.
Much obliged.
Supplementary list item number 1.
Please, my lord.
Motion. Motion. Yes.
My lord, the case pertains to an NGO whose FCRA registration certificate has been cancelled arbitrarily and illegally without applying the mind. Yes, it was cancelled for the reason that
When?
it was on 17th of February 2026. And 26. Actually, my lord, we had approached the Honorable High Court of Delhi, and the Honorable High Court directed us to file before the jurisdictional High Court. So we came here for this reason, my lord.
Yes, what are the reasons for
Actually, they invoke section 14(1)(e) of the FCR Act 2010, and the ground they have sought is non-utilization and non-receipt of
what kind of NGO is this you're involved
in development of the youth welfare and the public, including parting education and trading. They're not into any kind of activities which
trading, agriculture, or what?
Training. Yes.
Okay. Yes.
The
Where's the head office? Where's the registered office?
Their registered office is in Nongkrem.
In Nongkrem.
Yes, my lord.
Where's the impugn order?
Impugn order is on page number 24.
So you receive foreign contributions for 3 financial years.
Yes, my lord, 3 financial years because post-COVID.
The report is zero utilization. So you
Yes.
didn't use the money at all.
No, actually, we did not receive the money because in our reply we have specifically clarified that we did not receive any funds post-COVID.
But that was made clear to authorities, correct? The Home Affairs.
No, but the section invoked does not cover non-receipt of funds. It only covers not engaging in reasonable activities, or if the organization has become defunct. That is not the case here. If we have not received, then during the time when the renewal happens, they may consider that for that particular period they have not received any funds, so we may not renew it.
Take notice. Yes. Your name?
Kabir Hazarika, my lord.
Mr.
Kabir Hazarika.
Mr. K. Hazarika, and counsel with the petitioner. Issue notice returnable in 3 weeks. Dr. N. Mozikas with MS and Merchant present. Both the respondents?
Yes, ma'am.
Is present and both respond over a notice required. List.
My lord, I also have the interim application, my lord. It is
February order. We'll file affidavit.
all right. Deeply obliged.
The instructions are affidavit.
Do?
Lord, this matter pertains to registration of death, my lord. Lordship's,
Registration of death?
Yes, my lord.
Death?
Death.
Is death? Death and death.
Death. Lord, the Act I have enclosed at page 18, Annexure 1.
Yes.
If I take your Lordships to section 13 at page 27 of this Act, my lord, this is the Central Act. It's called the Registration of Birth and Deaths Act 1969.
Section 13.
Section 13 at page 27, my lord.
Yes.
So there are 3 instances, my lord, where subsection 1 of section 13 provides, my lord, if there and information is given within 1 month, my lord, to the registrar, my lord. Subsection 2 deals with beyond 1 month.
Yes.
And what is relevant in this case is subsection 3, which deals with registration of death after a period of 1 year. It reads, my lord, any birth or death of which delayed information is given to the registrar after 1 year of its occurrence shall be registered only on an order made by the district magistrate or subdivisional magistrate or by any executive magistrate authorized by the district magistrate having jurisdiction over the area where the birth or death has taken place, after verifying the correctness of the birth and death on payment of such fee which may be prescribed. So this particular death certificate was registered under subsection 3 of section 13.
After 1 year?
After 1 year, my lord.
Then what happened?
Now, my lord, before I take your lordships with the facts, may I point out section 15? Now, section 15 provides for correction, my lord. In the event, so it reads, my lord, correction or cancellation of entry in the register of births and deaths, if it is proved to the satisfaction of the registrar.
Yes.
So here the authority is registrar, that any entry of birth or death in any register kept by him under the act is, number one, my lord, erroneous in form or substance, or has been fraudulently or improperly made. So my case is fraudulently, my lord. He may subject to. I'll point out. I'll point out. Has been fraudulently or improperly made. He may subject to such rules as may be prescribed by the state government with respect to the conditions on which the circumstances in which such entries may be corrected or cancelled, correct the error or cancel the entry by suitable entry in the margin without any alteration in the original entry, and shall sign the so and so. So, section 15 deals with a situation where there's any correction, any entry which is erroneous or fraudulent or improper. Now the authority provided here is the registrar. Now there's a grey area because subsection 3 of section 13, which provides, my lord, if any entry, any information is given after 1 year, then yes.
Okay.
So, my lord, the only way under section 15 is to go to the registrar. So in this particular case, I had approached the registrar, but the registrar says, no, I have no authority because the order was passed by the executive magistrate. Now, what happened in this case is, my lord, factually, why I am before your lordships, no, there's a suit of 2022. Now, in the suit, the plaintiff and us, we were from the same family. We are from the same family. Our grandmothers were sisters. So the deceased person was my grand aunt. So there was a partition in sometime in 1994. Now, what happened is, my lord, in 2019, the plaintiff, my lord, who is also a party in this writ, my lord, had approached, my lord, the Schnong, which your lordships will find at page 81. This is a certificate issued by the Schnong in 2017. Typed copy is at page 82, my lords.
Yeah.
So the Darbar Schnong of Maujet village, my lord, on 5th of...
died in 1994?
Yes, my lord. That is the claim of the plaintiff.
17.
Yes, my lord. Yes. So the Darbar Schnong, my lord, issues a certificate that Srimati so-and-so, my lord, her date of death is 9/6/1994. So on the basis of this certificate, my lord, what they had done is, at page 85, they approached the executive magistrate, my lord.
Yes.
Of West Khasi Hills. If your lordships may kindly have page 85.
Yes.
Page 85, your lordships will find father's name of the deceased, so and so. Mother's name, Ngam Thanyang. This is the mother's name.
Yes, father's name. Okay, yes.
Saman. And mother's name is Ngam Thanyang. And then it reads, my lord, the order, seen the petition of Srimati Ngam Thanyang. Ngam Thanyang is the mother. For issue of court order to enable to register the date of birth of so and so. Now in the table, my lord, Srimati late Swantina Thanyang, date of birth, my lord, 1917.
Yes.
So the applicant, the petition was made by a person who was not alive, the mother, because the deceased herself was almost 100 years, as per this information.
See the bit of Ngam Thanyang. Now Ngam Thanyang is the mother's. Is the
mother of the deceased.
The mother of the deceased who was born in 1917.
Yes, my lord. So that's one, my lord. So this certificate was issued, my lord. Peruse the documents.
You can see the application.
Yes.
You have a copy of application. This is signed by Ngam Thanyang.
That's what the order says, my lord.
No, but the application, have you obtained a copy of the application?
No, my lord, we don't have that. Now, 2019. This is issued in 2019. Now, pursuant to this, my lord, a suit was filed, and this particular document showing that her death had occurred in 1994, on 9th of June 1994, they used this document as saying that a partition which happened a week later, that partition couldn't have happened because she already passed away in June 1994. Okay. Now they use this document in the suit. So thereafter, what we did was, because we have information that she died in 2007. So thereafter, what we did was, my lord, we obtained a certificate from the Darbar Shnong, my lord. If your lordships kindly have page 89.
So they gave another one.
They gave another one. This is in 2022.
He died in
2007.
So
thereafter,
2017 he said died in 94.
yes, ma'am. Thereafter, at page 91, even the church has certified that she died in
But
2007.
are they literate, these people who are signing these certificates of Darbar?
Malad, I'll just take your lordship to the official record. Now, thereafter, at page 93, I again approached the executive magistrate saying that there has been a fraud and the date of death has been recorded wrongly as 1994 while she died in 2007. At the last paragraph of page 93, your lordships will see. So the order passed by the executive magistrate is that from the above, if your lordships has that, from the above,
So the type copy.
typed copies, your lordships at
95.
At page 95, from the above, it appears that the petitioner had raised the same question, of which the same has been settled by the previous magistrate on 8/9/2022, in which this office is satisfied on the settlement dated so-and-so. I see no reason to interfere with the settlement already arrived by the predecessor so-and-so. So this was the order. So thereafter, what we did, my lord, at page 96, we had filed a revision petition, my lord, before the Sessions Court. But since this is an order passed by the executive magistrate, so we had to withdraw that particular revision petition. This is an application for withdrawal. Then we sought for RTI, my lord. RTI, electoral roll, my lord, page 101, 2005 review. Her name still appears, my lord, at page 104. Serial number 922. So this person was still alive even in the electoral roll, my lord, at page 104, serial number 922. And electoral roll of 2006, again your lordships will find at page 108.
Okay, yes.
Yes. Now thereafter, we made an application, my lord, before the DMHO, my lord, the registrar, at page 109, and an order was passed that no, we do not have any authority because the order was passed by the magistrate, the executive magistrate. Now your lordships will find there was an inquiry conducted at page 123. Page 123. This is dated 5th of December 2025. If your lordships, middle of the page, it says finding of the inquiry held on 10th December 2025.
Yes.
So it says, my lord, on 10th December 2025, we went to Ryangdo CHC, Maujiat village, so-and-so. Upon investigation, we found that the date of death of so-and-so is available and registered under the Registrar of Birth and Deaths, CHC, as supported by register available at the CHC Annexure 1 enclosed. Just for a moment, I'll take your lordships to page 125. This is the register.
1 second. One.
This is the register at page 125, serial number 18.
Yes.
So in the register of the CHC, minute, her death was recorded on 3rd of February 2007, Swen, Hanyang. So it is there in the register in 2007. If I may read further, minute,
So
the report.
What's the difficulty in them correcting this data?
Minute, their difficulty, the grey area is, if I go to the registrar says no, it is on court order, I can't. So, all we are seeking for direction from your lordships is to direct the executive magistrate to appreciate all these evidence, these registers.
I'll take instructions for respondent 1 to 6.
Very interesting case.
Yes, my lord, grey area. My lord.
Because we see there seems to be a conflict between section 13(3) and that 15.
So,
because then the
evidence
we have to
Because the magistrate conducts the inquiry.
Exactly, that is the only thing. Now, if now we go to registrar, if the order of magistrate is standing registrar, whether they have the power to to go on above the order of magistrate, it boils down to that.
There might be some instances of this nature. We'll do some research on this point.
Because then it's incongruous. It cannot exist.
Evidence will have to be led and.
No, evidence. I mean, there's 2 sections.
Yes,
reading
yes.
together, or you read them down, or you.
Yes, my lord.
Anyway, so but. The September Contempt petitioner issued notice. Mr. S. and the government advocate is present except on behalf of respondent 1 to 6. Was the issue 2. One was 7 within 3 days. Let's up to 2 weeks for instructions. Affidavit.
Deeply.
Item number 3.
My Lord, this is a second petition filed by the same petitioner.
Your Lordship, before he begins, there is another item in the supplementary list, item number 68, which is also a transfer matter.
Same petitioner.
And there is only one additional point in that 68 item. So my daily cause list, item 68.
Yes.
That also may be taken together.
Yes.
I see. You can them. Yeah. This case.
My Lord, I invite my Lord order to page number 21 of the petition, Annexure 1. In the first petition, my Lord passed his interim protection on 24th, page 20.
Yes.
And page 22, my Lord directed them not to give effect to the transfer order until they dispose of the representation.
Yeah.
Now, page number 23, we furnished the, my Lord, after Lordship passed the order in the evening, the petitioner received his release order on the same day, 24th, my Lord.
Yes.
And the next page, page 25, my Lord, we have informed the department about Lordship's order. And subsequently, page number 26, they passed the consequential order on page 26, Annexure 4.
Yes.
It's in the last, my Lord. Since that is hereby kept in abeyance till the decision and further order of the Honorable High Court of Meghalaya. So, in my Lordship order, they passed this order. And page number 27, they passed the former order rejecting my representation, page number 27.
What is the ground for rejection?
Now, the ground, my Lord, I may come to page point 3, point 4 and my Lord, 5, maybe relevant. It says, but the transfer has been ordered.
Point
number 4 and 5, madam.
4 and 5. Okay. Yes.
The transfer has been ordered in view of the organizational requirement, particularly in view of the centralization of corporate accounts wing at Guwahati and the need to utilize your services in the same wing for efficient discharge of the official functions. Clause 11.7 of the NIPCO transfer policy provides that employees due for superannuation within 2 years shall normally be considered for posting and location of their choice or nearest to their hometown. The said provision is directory in nature and does not confer an absolute right to remain posted at a particular station. The management retains discretion to deviate from the same in view of the administrative exigencies and functional requirements. Moreover, you have been allowed to work in your hometown for the last 29 years. Now, the two ground, what they say, the centralization of the account wings. Now, it was functioning in the headquarters Shillong. Now, during COVID time, what happened? Some of the officers who came from Assam functioned in Guwahati temporarily. And after COVID, my Lord, is no more, they remain functioned there. Now they slowly transfer shifting the department from NIPCO.
Why, Mr. General, the attrition is happening in NIPCO?
Yeah. Lordship?
Why the attrition happening in NIPCO?
Which one, sir?
Why is the attrition happening? Why are you trying to shift everything to Guwahati?
No.
We know also that even your quarters for your directors is not even occupying in Shillong.
That your Lordship...
We'll take note of this also, because you cannot, this is, you're eroding the entire, the very basis of what NIPCO is formed.
I'll reply to that.
No need to reply to that, but I mean, it's just to bring to your notice
Lordship,
that the court has noted that
I'm
not
also
in
fully
many
aware of
cases.
this fact.
Attrition is that because maybe certain interests are there.
Yes, there was some authority, and of course
your NIPCO headquarters to Delhi. Why keep it here in Shillong?
That is also your Lordship.
But take it to Bombay or somewhere.
Exactly what was the political pressure at the relevant time.
There's no political pressure. It's just pressure from within the organization for convenience. Now, after COVID, this is what happened.
Yes.
After COVID, your Lordship, what has happened?
After COVID, the advantage of COVID has been taken by many. It's not only in NIPCO that to function from very convenient.
Yes.
That is why.
Yes.
And small people like this who are about to retire in 10 months, you want them to shift lock, stock and barrel, and the excuse given is that 29 years. Why are you allowed 29 years to remain here then? If your corporate accounts section is there in Guwahati?
My lord, with great respect, my lord.
This is only one thing, just observation. It's not going to merits of the matter. But the attrition is very apparent.
Looks like.
Yes. Yes.
So I invite my lord attention to para 11 of my writ petition. On oath, my lord, we make a specific government. The board of directors, my lord, notice this, my lord.
Then file affidavit will stay this order.
Yes. And on 11 February 2025, board has taken decision to revert back from Guwahati to Shillong. Board resolution is there, my lord.
Where?
Page para 11 of my writ petition. We make a specific government.
Not that the decision of the court, but then we will examine because the ground set out for denial is or repetition is not. It doesn't, and where the judgment which is passed by this court needs that you frame your own guidelines.
Yes, yes.
And you are bound by them.
My lord, that is 2019. My lord.
Very old judgment, yes.
Yes. My lord elaborated dealt with that issue.
Now, where you frame your guidelines,
yes.
Now you cannot turn around and say that these are only guidelines, don't have statutory force. You are bound by your own guidelines.
Para 18 of that very judgment, my lord. I flag it, my lord.
We can't deviate from this.
Well, it says, admittedly, NIPCO is a public sector undertaking and has framed the transfer policy to regulate the transfer and posting of employees.
I remember the judgment.
Yes.
I can't deviate from
This judgment.
Exactly.
Yes, the judgment says that your lordship has already held that these are not the statutory rules,
yes, but then
and no legal right is conferred.
Exactly, but we don't frame guidance or rules for them to be violated.
Yes, lordship. These are subject to service exigencies. I'll make my point. I'll make my point. Let him finish, your lordship. Give me a chance. Give me a chance.
Of course, we'll give you. You file your affidavit.
Yes. Let him file affidavit shortly.
Lordship will file
the
affidavit at least on the. I may be hard on the interim prayer.
We'll hear interim prayer. Yes.
Anything else? I may be hard on the interim prayer.
Yes. What do you have to say? Objection to the interim prayer.
Your lordship, yes. Your lordship will see the impugned order is at page 27.
Yeah.
In the first paragraph, which my learned friend has conveniently not referred to, it is noted that you have rendered long service in NIPCO and has served in the corporate account wing for a substantial period, that is about 29 years, out of your total length of service about 32 years. Out of 32 years, your lordship, he has been serving for 29 years in his hometown. Now, your request for retention on medical ground has been produced. However, no material has been placed before the competent authority to establish any medical condition which constitute an absolute bar to transfer under the applicable transfer policy or service rules. It is further noted that the medical issues stated by you and your wife have been examined sympathetically. How the same does not have enough substances to override the administrative and functional requirement of the organization. Further, you may note that your new place of posting at Guwahati has better medical infrastructures, including you may note that your new place of posting at Guwahati has been medical infrastructure, including reputed government hospital. Then paragraph 4 and 5, your lordship, he has already read, your lordship. Now, my learned friend has already referred to and your lordship, I'll take to that that rule 11.7, the second writ petition. Second writ petition. These are not the absolute rules. These are to be read subject to your lordship. Your lordship will see these are there are overriding effect which has been given. Your lordship will see because the transfer policy is not annexed in this writ petition. It is annexed in the other writ petition, item number 5.
Yes.
Item number 5.
Yes, we are aware of that 11.7. Yes.
Yes. Your Lordship will first see at Rule 4, objectives of what is the objective of the transfer policy. To cater to the changing needs of the organization, to ensure optimum utilization of manpower and their knowledge of skill. Here, Your Lordship, is the case where the writ petitioner is specially trained for working on the centralized accounting system. The corporation recently, Your Lordship, has introduced a centralized payment system of all the bills. Here, that system is being operated at Guwahati for the entire Northeast. Now, all the bills, even over bills from Shillong, and from Arunachal, all the Northeast bills goes in Guwahati, from where it is centralized, and only some officers are trained till today.
What is the level of his, which level of?
Assistant manager, my lord. Assistant manager.
And he is trained for that purpose, and to cater to the needs which is provided in clause 4, the management has taken into consideration that aspect. Your Lordship will see, then come to Rule 5. He is posted from Corporate Office Shillong to Guwahati, which falls under category 1. Guwahati, Your Lordship, is not far off. It is just a 2.5 hour, not even 2.5 hour state journey, and where there are better medical facilities. And he has been in the hometown. We have kept him for 29 years on one or the other grounds. Not the corporation needs his service. Lordship, then I take to Rule 8.1. 8.1. Notwithstanding any provisions contained in this policy, the management reserves the right to transfer or retain any employee at any place irrespective of his or her tenure at a particular location in order to meet the organizational requirement and in the interest of work of the corporations. So this clause 8.1 gives an overriding effect. Then Your Lordship will come to Rule 15, page 20. Now, before that, Your Lordship, he is referring to Rule 11.7, and the Rule 11.7 starts from Rule 11. Your Lordship will see Rule 11. Special consideration shall be made while deciding transfer and posting of employees in the following cases in consideration of the organizational requirement and the merit of the case. So this also provides, Your Lordship, that the corporation organizational requirement and the merit of the case. Then Your Lordship will see paragraph 15.1. Request for transfer on special ground like medical care of self, family members, so as defined in medical attendance rule, education of children, aged parents, employment of spouse, etc. shall be submitted along with transfer options through factor like length of service at a particular place. Functional criticality, medical grounds, etc. However, functional criticality requirement will have overriding priority over everything. Clause 15.2 again gives the overriding priority to the functional criticality, Your Lordship. Now, in this connection, Your Lordship, I refer to this Honorable Court's judgment of Division Bench. That is, Your Lordship, the case of 2020, it is a reported judgment, 2022 SCC online Meghalaya 592. This was a case, Your Lordship, decided by Your Lordship. Then we went on appeal before the division bench. Division bench set aside the judgment of this court. Then the petitioner went to the Supreme Court. On the Supreme Court also, the division bench judgment was not interfered.
Division bench judgment, this one?
Yes. No, this is Supreme Court, I think. We have given SCC. 2022 SCC online Meghalaya 592. I am just reading paragraph 2 first. Lordship, got it? It is too late in the day to emphasize that the High Court's authority to interfere in matter of transfer is very limited, and unless a case of egregious malafide is made out, the High Court must yield to the administrative reasoning of the employer. Indeed, once an employer cites administrative exigencies for the transfer of an employee who holds a transferable post, it is almost the end of the matter, and the High Court ought not to interfere therein. There is no allegation of egregious malafide. This division bench has held that there is only one ground, Your Lordship, of interference, that is egregious malafide. There is no allegation against any of the respondent. Then Your Lordship will see paragraph 7. There were certain grounds at paragraph 6 which were taken. Like here he is taking the transfer, the shifting of the office. It is unrelated to the transfer matter. My submission is this is not related to the transfer matter. In that connection, Your Lordship, paragraph 7 I refer. With respect, the substance of the matter was the transfer of an employee, and the perceived anomalies noticed were incidental and too insignificant to be given any credence in the larger context. Then, Your Lordship, I refer to paragraph 11.
It is not connected, but then in your own impugned order, you refer to that.
Which one, Lordship?
In your own impugned order, you said that the rejection of transfer due to the shifting
functional
of
criticality.
Yes. Where is that? It said because. Yes. Where is that?
Yeah, not. I remember that shifting is not nowhere mentioned. Which is being operated. Recently, it has been being operated.
Corporate accounts wing at Guwahati. Right.
Yes.
That's the reason given.
Yes.
Right.
Yes. Because this was a new system which is introduced. Then Your Lordship, refer to paragraph 11. This was not.
This is a different context also, Mr.
No, Your Lordship, the context may be different, Your Lordship.
Settle law is that transfer is instance of service, yes, and that no employee can challenge a transfer.
Yes.
Now, only your case has looked into two aspects only. One is that you've allowed him 29 years to serve here. Why didn't transfer him earlier?
No,
Number
Your
two,
Lordship, this
number
was,
two,
this
that cannot
was
be used.
on
That cannot be used as a reason to deny to transfer him now. And number two is that he's the fag end of his service. How many months you have left?
14 months.
14 months.
14 months. Yes. 1 year, 2 months.
No, Your Lordship, that he has not a vested right to carry on throughout his 32 years of service in the Shillong.
Why you allowed him to
29 years because of his own requirement.
Where is that?
Own requirement.
Where is that? He's put The representations are there.
No, representation, your lordship, for everything there is no representation because our corporate, he has been telling to the authorities concerned. No, while disposing of this representation also, he met the director finance, who is the competent authority. He has given him right of hearing, and unofficially, your lordship, of course, I have no.
We will not disregard your submission. Only that.
Your lordship, only my humble submission, your lordship will be there.
With regard to transfer.
After all, your lordship will appreciate that we are the organizations. If the transfers are
with regard to the law regarding transfers, ironclad. There's no question of revisiting it. Like the judgment division bench, okay, it says that it just reiterates that position.
Yes.
That transfer is transfer. So that the courts are slow to interfere, right? But in some cases, why transfer orders are examined because the circumstances which surround it, and each case is different.
No, your lordship, here is the case, your lordship, when the department has considered his representations.
Yes.
And gave him a chance of hearing. And he, as a matter of fact, your lordship, this division bench has also held that this sort of practice is an abuse of the process of the court. Your lordship will see paragraph 15, the last two lines. Paragraph 15.
See, it's not a usual course it's not the usual course of an employee transfer.
Yes.
It's a usual course. See, your policy says one person shall be posted maximum of 4 years in a
Yes.
Correct?
Yes.
Yes. Now,
no,
4 years
the management at the same time, your lordship.
Please listen. Now, 4 years in a post, right? That is the scheme of your policy, transfer policy, right? Now you're saying no employee has the vested right to ask for you transfer is served for 4 years maximum. Now, what have we done in this case?
Yes.
Although right, but in the end, the rule consists that you see, if a person is dislocated, the last leg of his service.
Lordship will also.
That's the only thing.
And bear with me for 1 minute.
How crucial is service?
That 4 years of the normal tenure. Now he joined in the service as a workman. He got promotion, and there is no denial of the fact he has been very hardworking, and very efficient persons. And this efficiency comes from where? From working in the corporations. Now the corporation requires his service for some period.
Yes.
To go down to Guwahati, what is his problem, your lordship? I really fail to understand that.
59.
And he has been 29 years, your lordship, long period.
Exactly.
29 years. And your lordship, one more judgment, if your lordship permits me.
Please.
That your lordship, that judgment of your lordship is reported in 2019 SCC online Meghalaya 233. This your lordship has taken a lot of pain in writing this judgment.
Yeah, because he said the contract of personal
yes, contract of personal. That question was left open, your lordship.
Yes.
And this cannot be enforced. And also your lordship has held in this case that I may be subject to the writ petition under Article 226, but it's not that my every action is subject to Article 226. If it is a private right, this cannot be enforced under Article 226. That was the observation of this court.
It's a different case.
No, your lordship, I think this is the same case.
Okay.
Now your lordship will see the last finding, paragraph 21.
Yes.
In view of the finding as recorded herein above, and the taking into consideration the applicability of the transfer policy of NIPCO to all of its employee and reliance also being placed on the same by the respondent senior counsel himself in his submission, there can be no doubt as to the relevancy of the policy concerning transfer and posting. On the aspect as to whether NAPCO, though amenable to jurisdiction, would come within the definition given at para 52 clause so and so KK Saxena case. And this, Your Lordship, the KK Saxena case is referred by Your Lordship at paragraph 52. Paragraph 16. Now, this was the very old case which is referred. Thereafter, the law relating to transfer has undergone into changes. And present situation is this: save and accept the ground of mala fide. Nothing more can be done. Though amenable to jurisdiction would come within the definition given at para 52 clause. Your Lordship, Saxena judgment, and whether the bar by application of the specific relief act will be attracted in view of the discussion and finding above are left open. Your Lordship have not decided, of course, that point, but that point still remains. Section 14(1)(b) of the Specific Relief Act specifically provides that the contract of personal service cannot be enforced. So this is a private right, Your Lordship, private right. And that apart, Your Lordship, the reasons given by the corporations, APEC court say this cannot be the subject matter of review. Now, in Bidut Goswami case, Your Lordship, that is division bench case, only one thing more, Your Lordship, I would like to point out. Paragraph 12, just Your Lordship will have a look. The division bench has already held. Paragraph 12, Your Lordship, of the Bidut Goswami case. Yeah. Paragraph 12. Last line. Further, Rule 15(1) clearly stipulates that the functional criticality or requirement of the employer would have overriding priority over anything else. So, Your Lordship will take into consideration this aspect, and also, Your Lordship, I would point out one more judgment, that is SC Saxena case 2006 9 SCC 583. Paragraph 6. We have produced the record with the help of the learned counsel and heard the learned counsel very patiently. We find that no case for our interference whatsoever has been made out. In the first place, a government servant cannot disobey a transfer order by not reporting at the place of posting and then go to a court to ventilate his grievances. It is his duty to first report for work where he is transferred and make a representation as to what may be his personal problem. This tendency of not reporting at the place of posting and indulging in litigation needs to be cut, Your Lordship. Let him go and join, Your Lordship. He can make the second representations. And out of the court, Your Lordship, I may just say that I personally will look into it. May not be recorded, but he must comply with the order. Otherwise, administration of corporation cannot run, Your Lordship.
Yes, my short submission, madam.
Yes.
My lord, the Board of Directors has taken a conscious decision on 11 February 2025 that functioning at Guwahati There was no order, therefore, offices functioning in Guwahati should be shifted from Guwahati to Shillong. Page para 11 of my writ petition.
That is
Let them reply. Para 11 of my writ petition.
282.
Yes. 3310. 30.
Para 11.
Para 11.
No.
Madam.
No, what's this?
Para 11 of my writ petition.
Of WPC number 282.
Of WPC number 310. 301. The first motion, madam.
Today?
Today one.
Oh. See, the only remark, Mr. General, just to.
This is very serious, my lord. The apex body of the corporation has taken decision to shift, and for vested interest, some of the officer has transferred. Lordship, can you see para 11, specific government?
You have any? Yes.
Madam, may I state, it is pertinent to place on record that realizing the strong resentment of the staff and the public for gradually shifting the cooperation of the NEPCO from its headquarters in Shillong to Guwahati to accommodate the interests of few vested officers who takes the advantage of COVID crisis and prefer to work in Guwahati unofficially without any policy decision taken by the competent authority. The writ petitioner also came to know that the respondent board of directors in its 292 board meeting of NEPCO held on 11/2/2025 consciously adopted resolution and directed that all the departments along with the manpower shifted from Shillong to Guwahati should be immediately reverted back to Shillong headquarters. This honorable court may be pleased to direct the board of directors.
Just now I got the information with regard to this para. Statement made herein is not correct.
What has happened
in this matter, that the board resolution which is referring is about the shifting of some of the two offices only, and in that corporate finance wing is not included.
We'll note it. We'll pass orders. No need for affidavit.
Yes, let them file affidavit, my lord.
No, we'll dispose of the matter.
May just a follow Lordship consideration. I've cited two judgments where Supreme Court held that the bylaws, policy guidelines on transfer, until unless it's changed by department is bound to follow.
No, the guidance will give them enough latitude, but only circumstances of the case.
Now, the reasons cited by the respondent that I work here 29 years, that cannot be the ground for me to transfer against their own guidelines. Yes. Policy.
Your Lordship, so far the other matter.
1993, my lord. 1993, volume 4 ACC, page number 25.
Page number 25.
My lord, relevant para is 14. My lord. There was a transfer matter. Para 25, para 24. Para 14, my lord.
You have given a list of books.
May I read?
Given
14, my lord. It may be relevant to emphasize 1993, volume 4 ACC, page number 25. Page 25. 25.
Para 14.
Para 14.
Para 14.
Please. Paragraph 14, ma'am.
Page 25.
Page 25. The Home Secretary, UT of Chandigarh versus Tarsit Singh Grewal, ma'am.
Again. 1 second.
1993.
Was Darsit Singh Grewal?
Yes.
That wrong. Yes.
My right says. It may be relevant to emphasize at this juncture that while the rules and regulations referred to above are statutory, the policy guidelines are relatable to the executive power of the Chandigarh administration. It is also axiomatic that having enunciated the policy of general application and having communicated it to all the concerned, including the Chandigarh Engineering College, the administration is bound by it. It can, of course, change the policy, but until that is done, it is bound to adhere to it.
What about this unit, this SL Abbas? Who said this? 93, 4 HCC,
yes.
57? Your judgment?
Second judgment is 1983.
Okay, that's bylaws. Yes, what about this 1993 for ACC 357?
Yes, I'm the one, man.
Yes.
I'm the one cited. 1993 volume 4 ACC.
But that is against you.
No, it is in favor, man. There was a policy guideline was not followed. Therefore, Supreme Court said it should be unless it is changed by department. It has to follow. Man.
No.
It is against him.
No.
Yes.
Paragraph 6, 7 and 10.
Not following instruction guideline not sufficient to quash order has been malafide. Okay, no, grounds for malafide. Yes.
Yes.
This won't help you. So
But the relevancy of the binding nature of the guidelines is upheld by the Supreme Court. In second judgment, my lord, page 1993, volume 4.
OACC I5.
1983, volume 4.
Page
1983, volume 4 ACC. Page number 582. 582. Relevant para, my lord, 23 and 24. 23 and 24.
Yes.
Well,
no, we'll pass order.
Well.
So far the third matter is concerned. Third matter from the main list 68. Your Lordship, there is only one additional point which is there in that writ petition. That is, the transfer order is not a transfer order. It is just a temporary detailment. Just your Lordship.
Separately then. We'll dispose the matter first. There's a stay order operating there also. No.
Lordship, yes, in this, there is a stay, Lordship. I have received they have filed the affidavit. I want to file a rejoinder. Lordship, what here again, mine is different from the other one. Lordship, in mine, I have only 9 months for supernovae. And Lordship, if I take it to the order, Lordship, if the transfer order, they say that it is a temporary detail. These, Lordship, they are 3 different places, Lordship, which is in a terrain area, and it is of 15 to 25 kilometers where he has to travel to look into all these projects, Lordship. And Lordship, and there in that order there is no exigency shown, Lordship. Number 1. And number 2, Lordship, from my representation,
We'll
which
take
I
it
had,
differently than you file rejoinder.
Yes, Lordship.
They'll be called
and
out.
interim is there, Lordship. Interim will be continued, Lordship, till that.
Your Lordship, may I just refer to annexure, page 22 of the writ petition, which is filed by her?
No, we're not. The matter is not before me. Since it we called out, and we will call.
Right.
Item number 4.
Very please, Your Lordship. I have filed an application, Your Lordship, praying for under Order 6, Rule 17.
Where's Mr. Jindal?
I'm on behalf of Mr. S.T.
Any objection to the prayer?
First for conversion.
May I please, Your Lordship? No objection.
Yes, sir. Just miss case.
Yes.
Number, miss case number 14/2026. 14/26. So in supervision, there's an application seeking leave of this court to treat the instant civil revision application inadvertently filed at 227 to be treated as writ petition Article 226 of the Constitution. Stop. Mr. S. Goenka appearing for the respondents has no objection to the application. Stop. Peruse the same. This court is satisfied with the grounds set out, and accordingly, the instant civil petition will be re-registered as a writ petition. Registry to witness the correction list after 1 week.
Yes,
deeply obliged.
Much obliged.
Daily list, item number 1.
This matter, my lord, is directed against an order, my lord, 25
But
to
the chanda was the
2026.
chanda. What instruction have you received? Yes.
My lord, may kindly have There was an order, my lord, directing both the parties, referring both the parties for arbitration, my lord. That your lordship will find at page 15. They've conceded to the my lord to refer the matter for arbitration. And my lord may kindly have the date on which this order was passed. My lord, para 2 at page 15, my lord, is a reference to the arbitration.
Then what remains here?
My lord, now what they have done interestingly, my lord,
Para 2, page 15.
At para 2, my lord, the parties have been referred to arbitration. Page 15.
Yes.
My lord, on consensus, my lord, this was referred to arbitration.
Yes.
My lord, and thereafter, my lord, post passing of this order, my lord, at page 18.
18?
Yes, my lord. They issued a legal notice, my lord, demand notice rather. My lord, I'll
Not be inadvertently when this order passed.
this
Now,
order, no, my lord,
arbitration
cannot be
correct.
inadvertently, my lord, because
It was also already before the arbitrator now.
it is before that. They are aware of this aspect.
You heard Mr. S. Thapa who submits that even though the matter is before the arbitral tribunal as directed by this court by order dated
25/2.
25 to 2026, a notice dated, a demand notice dated May 12th has been issued by the respondents. You have not taken step here?
No, my lord.
Yes, sir. That notice issue. That notice issue. Just after. Earlier steps were taken within 2 days. Just after 2 weeks. Yes.
Deep level.
Item number 2.
My lord, in this matter, earlier occasion, lordship allow me to file an affidavit. We are unable to file it, my lord. To bring on, in fact, we have submitted that letter earlier. A lordship directive to place on record officially by way of a short affidavit. We are unable to file it, my lord. Lordship, give me a
You are appearing for the
council. For the 1 to 4.
Mr. Manta, you are appearing for
Number 7, lordship.
have you bring what you file affidavit?
Yes, no, lordship, he's also yet to file.
Decision.
Why?
I got it.
Put an affidavit.
By affidavit. All right. I could not file because
Yes,
allow us some time.
though this
Allow us.
court by order dated 15/6/2026 had allowed the respondents 1 to 4 to bring on record notification dated 20th May 2026 and also allowed respondent number 7 to bring on record proceedings for a meeting by executive committee. Today, the London Senior Council pray for some accommodation. Yes, accordingly, pray for the action filed within 2 weeks. Yes,
Published, lordship.
yes, thereafter.
Still item 44.
45.
Still item 40. Published.
May it please yours.
Lordship, I'm appearing for the petitioner in item 45.
Yeah.
I'll be seeking a password. I'm seeking an adjournment. We are being led by Senior Advocate Salman Khurshid. Is not available today.
When do you want it? Yes, Mr.
To your convenience, my lords, anytime after a week will also be.
After 2 weeks, because this next week.
Yes, sir, on the prayer of your Mr.
Surya Kiran.
Yes, for the petitioner. Yes, due to unavailability of the arguing senior counsel, this matter appear after 2 weeks. Yes. Yes.
46.
Where's your rejoinder? You filed it?
Lordship, we are ready with the rejoinder, but
File the course of the day.
we'll file course.
Yes, you Mr.
Pinong Singh.
Mr. Pinong Sage for the petitioner submits that rejoinder is ready. You file the course of the day. This is for hearing.
Yes, Your Lordship.
Just a matter for hearing for 2 weeks. Yeah.
I oblige, Your Lordship.
47.
Where are we in this matter?
Yes, this is the affidavit, my lord, we have filed.
When have we filed it?
You have filed it. Morning. Item number.
So yesterday,
Yes, 50.
office note shows that not filed.
50. Yes, item 50 we have filed it. And that will cover.
Item 47, 48, 49 should be a connected.
65 also. 65 also. 65 is what?
Yeah, 65 also. 50. One at a time. Yes.
Item 50, my lord, will see the counter affidavit and item 50.
It's not come on board.
So we have filed in morning.
Have you served copies?
I'll serve the copies on all the parties, my lord.
What about the other items?
This counter will cover all the items, my lord.
Entire case.
Item 47 and 48, these are all connected matters, Milits.
No, one thing.
49,
47,
your lordship,
47,
48, 49, 50, 65.
The RFA Journal has said that one affidavit which is being filed in item 50 will answer all the cases.
All lordship. Issue is identical in all matters.
So it'll suffice that affidavit. You want rejoinder to it, Mr. Paul?
My lords, I have not received a copy.
We will serve. We'll serve a copy. We'll serve the copy on all the parties.
49 wala lordship, subject to lordship correction.
Okay, they have just filed it. Yes, Learned General submits that.
May I just point out?
Yes.
Very limited issue, depending on what the state wants to say, but very limited issue. We are simply saying, the state again reconsider all these cases,
No, fine. Let's see what they have, what they say in the affidavit. Then we can maybe dispose of next day.
The advocate general can just place the affidavit.
Yes, Mr. Then Advocate General submits an affidavit. Has already been filed. Has been filed this morning itself in item 50. He further submits that this affidavit will suffice to answer all the connected petitions, as the issue involved with is identical. The learned counsels for the petitioners, however, have not received a copy of the affidavit. Pray that the matter be posted and when
After a week.
after 1 week. After 1 week, we allow them to
Serve the copies on all the parties.
To obtain instructions. Respondent to serve copies of affidavit by today itself. Yes. After 1 week.
My lords, liberty may be granted to us to file a rejoinder.
No, let you see first. You haven't seen the affidavit. Yes.
Subject to lordship correction, my lord, I have 49. I have not received any copy of.
We'll serve on your local counsel. We'll serve.
So liberty to file, my lord.
Of course, yes. Yes.
Obliged.
51.
We are in the process of filing the impleadment application, my lord. We were required to file some impleadment application, my lord.
How many weeks have we allowed for one impleadment application?
My lord,
now
the respondents apparently are from Kerala, my lord, and we do not had initially we had no details about their address. Somehow we have managed to get that, my lord. So we are in the process of filing it today, my lord.
You are for whom?
For the respondent mine, for the bank.
Yes, Mr. S. Thapas. Course of the day filing it.
By tomorrow, my lord.
Submits that as the address of the party sought to be has been obtained, he pays allowed 1 week's further time to file the necessary application.
No.
Yes, pays allowed.
52.
Yes, on so and so. Five to 7. 4.5 to 7.
1 to 4.
Where is the affidavit? Why?
Because I highly object to that since we have filed this since last year, and they have now the respondent 5 and 6 came and illegally demolished my house in a jiffy. And now they have taken so much time to file a simple affidavit,
You demolished the house and now you're not. As quickly as you demolish the house, you file an affidavit. Otherwise, when is it demolished?
The 2024, my lords, the month of November.
This house is under the
And the PMGY scheme.
It's under which scheme?
PMGY scheme.
The demolished under, because it's on whose land?
It was constructed under my land, my lords.
They see it on village land.
There was a dispute, Your Lordship.
So then who will compensate?
It was constructed in a place not designated to be constructed, Your Lordship. That is why we have issued a notice to recover the money.
From the petitioner?
Lordship, yes.
Then who constructs this PMAYG scheme? Is done by independent contractors or done by the
No, the money is given to the beneficiary. She is the beneficiary, Your Lordship.
So how much money did you get?
I've received 1,20,000.
In lakhs, Your Lordship.
So you build a house in someone else's land?
No, it's my land, my lords. It's my land.
There was a dispute, Your Lordship, regarding the land.
I've constructed the land with the consent of...
We need the affidavit. Don't. Otherwise, you'll have to pay cost.
We'll fight the course of the day.
On the course of the day filing, Mr. Kiwi Karindo appearing for respondents 5 to 7 submits that affidavit filed the course of the day. Just after 2 weeks for rejoinder of any. Then we dispose it of it.
Lordship. Obla, Your Lordship.
53.
So when is construction that they don't go and check from the government
Lordship,
whether
in fact,
the money given by the
because
state
what happened, Your
for
Lordship,
BPL housing is
it has been shown in at the time of the inspection, the different land was shown.
But after the construction, no one goes and verifies. Then how can you ask for recovery?
I'll place my case, Your Lordship, at the time of.
Yes, Mr. Sheikh.
Chief, here in this case, the governing body of the college has filed an affidavit whereby they have enclosed one document that the minutes of the meeting dated 21st February 2025. In the meeting, they have taken a resolution, they have withheld my seniority, Lordship. Now, what I have got through the RTI altogether a different resolution, that is 21st February 2025, but that resolution has not been supplied and that is affecting. So, I just want to withdraw with the liberty to file a fresh Lordship, challenging this minutes also, Lordship.
Yes, Mr. S.A. Sheikh submitted due to certain developments wherein what has happened?
My lord, there is a governing body resolution that is 21st.
Governing body resolution dated 21/2/25 has come to light. He prays me to withdraw an instant application. Will liberty to file a fresh. So advised. Yes.
Published.
54.
Prayers allowed on the submission of the council. Matter stands closed on withdrawal.
Yes, liberty.
That's prayed.
My lord.
Published.
Yes.
Lordship, I'm praying that I may be able to take steps on the newly implemented respondent 5.
Just MSBF Karanalang. Who you'll accept notice?
Your Lordship, I've already accepted.
5. Then?
5 is state,
State,
Your
Your
Lordship.
Then who'll accept notice? This is a miscase for impleading.
Yes,
already
yes,
impleaded.
already implemented, Your Lordship.
I mean, this,
Lordship, I'm just praying that notice may be issued will take steps.
yes, by order dated 23/6/2026, the State of Meghalaya through the Department of District Council Affairs has been impleaded and arraigned as respondent number 5. Stop. Let the notice issue to the said respondent within 2 days. Yes. Yes. Or that notice issue to the no, that notice issue stop. Mr. N.D. Shulai, then AG Howard, Mr. Jindra, Mr. Rinja are present, and as such, no further notice required on the said respondent.
Only a copy of the
I'll serve a copy.
Information be served on the newly implemented respondent
Your Lordship,
within 2 days.
once more prayer since the district council respondent last time they informed the court that the act was
Repealed.
Your Lordship, I'll file it.
Lordship, if they can bring that on record.
I'll file it by way of an affidavit, Your Lordship.
Yes, MS P.S. Nongri also further submits also submits that as the pension, what is the act for?
The Khasi Hills Autonomous District Council.
KHDC, what is
Bracketed members pension. Bracketed members pension, then Act 2012.
Bracketed members pension Act 2012.
2002, Your Lordship, sorry.
2002. She prays that she will have to bring this fact on board by way of an affidavit. Praise also allowed. Just after 2 weeks for further orders. Yes.
Highly obliged.
55. 55.
Has received the assent of the
55 is connected to
It has been published in a gazette.
Yes.
56.
Lordship, this is that contempt matter, Lordship.
Yes.
Lordship, if I can refer, Lordship, to the affidavit filed by the respondent. Lordship. I filed, Lordship.
Then
Lordship, my humble praise, Lordship, this contempt petition can be closed, Lordship. If the respondents issue an order effecting what has been made in the abovements in para number 5, Lordship, of the affidavit, then, Lordship, this paragraph.
Correct.
No, in fact, what has happened, Your Lordship, it can be closed, but what further order, I don't know. But one thing, Your Lordship, he has already been there, Your Lordship's order has been complied with, because they have already passed an order.
We can't pass for the directions.
Lordship.
That direction cannot be issued. That is what I am.
Lordship, in that case, Lordship, this honorable court's order was clear-cut, Lordship. The order of reinstatement,
The
Lordship.
thing is that, see, there are two things only. Whether the order is violated or not. We can't go and, into an area of,
My submission is the order has been violated, Lordship, but they have not acted on the order,
we'll hear
Lordship.
it. We'll hear you.
No, Lordship, I'll just point out two things, Your Lordship.
If you find out, you make a
Very
violation,
well.
we'll issue proceedings.
Questions of violation will come if there is a disrespect or not following the order. If your Lordship's order was passed in first week of December, he retired on the last week of December. Within these 3 weeks, Your Lordship, and there was a holiday for Christmas and all in the last part. These 2 weeks
Then
part,
see, if
2 weeks, Your
where's
Lordship,
government
what has
gets just-
happened?
let's
We
see,
could
para
not
five,
raise.
where's it?
Lordship.
We have annexed certain documents also.
Yeah,
Your Lordship.
just take the code to the document.
Lordship will kindly see the document that I have annexed at page 9 of my affidavit, Annexure A. This immediately after your Lordship's order, we have already issued a letter for constituting the Executive Council for your Lordship compliance of this order. This, Your Lordship, will kindly turn to page 10, sorry. 10, what has happened, Your Lordship? Because, Your Lordship, because of the unrest, there was some difficulty for...
Yes, Mr. Pani will close it.
Lordship.
Yes, in view of the affidavit filed by the respondent.
Lordship, one submission, Lordship.
No willful
Lordship,
violation of the order of
Lordship,
the court.
otherwise I will not get relief, Lordship. They have been sitting on my reinstatement, Lordship.
Mr. Pandey, if there's compliance to some extent,
There is no complaint, Lordship, because
They
see,
will hear you.
Lordship, let me just read paragraph 5,
We'll
Lordship.
hear you.
Okay, Lordship.
Already, yes. Things are complete. The journal has been filed. Just a matter for hearing up to 2 weeks. Yes.
Lordship.
We'll give you enough. You can see whatever you want.
Lordship.
57.
Deep obliged, Lordship.
57.
Received today?
No, sir. It was received.
What's it for today?
My lord, the respondent was asked to take instruction. They have supplied me one copy of the instruction. But as per the order of this honorable court, my lord, the order has not been complied with, my lord. First thing first, my lord, the inquiry report has not been supplied to me, even though I've received a bunch of the entire documents which were supposed to be supplied, but the inquiry report has not been supplied. Number one. Number two, my lord, the area salary has not been paid to me, my lord. That was a direction by this honorable court. That is admitted as per 2.4. If your lordship have this letter dated 22nd May 2026, my lord.
22nd May. Annex the affidavit?
No, my lord. This was.
What have you filed today?
My lord, I have filed this affidavit to bring on record that fresh proceeding against me has been initiated.
Yes, Dr. Mazika.
My lord, just now I received this, my lord. I'll need to take instruction.
But you didn't supply copy inquiry report in the bunch of papers. Why?
No, my lord, there is
not even available, my lord.
I placed a receipt also, my lord, and she has signed that.
So, of course,
there
the
is a
paper she
receipt copy
received,
of
but
previous
the
department.
inquiry report is not part of the record she received. That's the allegation.
Yes. It's not. The entire record was called for before that the initial proceeding, my lord. Before the judgment was passed by the single judge, my lord. Even there, in the records, the inquiry report was not available, my lord.
I was not. But the receipt that has been, I'll have to go
we have received, my lord. All the other documents are there except for the inquiry report.
But I'll get a copy of inquiry report and
An affidavit on behalf of the petitioner has been filed with the record memorandum dated 29 June 2026, whereby a fresh inquiry is contemplated against the petitioner. Stop. Next paragraph. Mr. Dr. Mbozika, please without to obtain instructions in the matter. Yes. But it's after
2 weeks.
2 weeks.
58.
Obliged. Very pleased, Your Lordship. Your Lordship directed me to produce the record. This year. The record.
What's it for today?
For the Lordship, those sublease, those tenant subleasing.
There was fire incident, my lord, near Anjali Cinema. There was a fire incident.
No, that remember now. What's for today? Why was records for?
No, because they said that nobody was present when they went to inquire. This place, all of them have left. This is the record they are producing, my lord.
But they already have photographs here also.
Yes, everything is there. Even the records on 29, we have intimated on 30th, they are coming to inspect.
But my lord, no such notice was.
No, it is there.
No such notice was sent, my lord.
How who was sitting here? How do you know who was there, who was not there?
That is, my lord, the problem is that had they informed in advance.
Try just trying to bring out some, what do you call it? To give you some relief. Those people staying there to make some shelters which are improve waterproof. But then now you say they were not there, you were not there, an infection was done. What are we to do?
But at least notice should have been issued that an inquiry will be there, survey will be. No notice was issued.
You see the file.
It is there in the file. The flag mark.
How will we monitor whether notice has been issued in a proper manner now?
Now they have replied also, Your Lordship. It is there in the record.
Who has replied?
They have replied. They listen.
Representation here, 21-4.
Yes, they have replied.
This inspection was done on
30th, 30.
30th of
April. On 29th, we issued a notice to the lessee.
Om Prakash Goenka.
All three. Then
Kamal Kumar Goenka.
No one remained.
Then let's see.
It is there.
Now you are Santosh. Who's Santosh?
I'm for respondent number 6, Santosh Devi Goenka.
Yes, and then you have given the list of your tenants also.
Yes.
16 number.
Yes, Your Lord. And the notice which my learned senior friend is referring to is notice dated number 29 April 2026. In that notice, Your Lordship, nothing is mentioned that on that particular date, all the people, all the residents have to be present in that particular place. They have just asked me to submit the list of tenants out there. So I have done accordingly.
So they have given 16 names of the tenant, but none of them were present.
See, why you were not present?
We were present, Your Lordship. No notification was issued like on such and such date that such.
See,
Yes,
you are the leaseholder, correct?
Yes, Your Lordship.
Then you have those tenants in your land, correct?
Yes.
That means you were present.
I was not informed, Your Lordship. I was just
present also.
No, Lordship.
Were you present or not?
No. I was not there.
She intimated. The letter is there.
Letters, Your Lordship, letter is already mentioned that submit the list of tenants. So I have complied with that letter.
On the ground realty, only 5. Actually, 3 of them were found. Only 5.
Very difficult.
Other 2 legislations, there, most of the tenant they left.
My lord, to settle the matter, a date should be fixed by Your Lordship. On that day, all of them will be present.
You want the court to go there?
No, my lord, a date should be fixed. Let them go in and survey the thing. Only date should be fixed by Your Lordship.
Then on that day, you'll have a lot of people coming.
No.
Yes, you see, the inspection was done. It's good also that the date is not given. So those people in actual who are living there, they'll be present there.
Only 3 of them were there.
They are the daily wage earner. In the morning they go, in the evening they come, and when they went there to survey the thing, we don't know even.
So everyone leaves the compound.
No, not leave the compound. In the daytime they go for working.
Everybody leaves, deserted.
But my lord, there is no house, nothing. Where they will live, my lord? No house remains there after
So
the
where are you staying now?
They are staying with some relatives, but once they are called to come here, they will come. In the morning they go for the work, in the evening they come back. Even the respondent number 6 does not know when they came to survey it, who is living himself there.
We can't, this matter has become difficult to adjudicate. We're just trying to allow your petitioners to raise whether, windproof during the monsoon so that they will not be, exposed to the weather.
But my lord, if a date is fixed from your lordship, let there be survey on that day. Not by the court, but
How
by
many
the...
times will there be inspection? See, I just read the report. The office letter so-and-so has requested recorded lessee is upon to submit as occupants to sign the area. In response, Srimati Santosh Dev Goenka has submitted a list of names, number 16 numbers. Om Prakash Goenka and Kamal Goenka recorded lessees of 129 submitted. More tenants have already shifted, with 2-3 tenants residing, but no names have been submitted. These inspected. On inquiry, the female persons present at the plastic sheds have said maximum male members have gone for daily work, but then stated the foreign persons are staying in the shed. So only seven. How do you verify
And those also not the petitions, my lord. Those 7 also not the name given in there. They are not the petitions. So at least an opportunity should be given to the petitioners to be present
What do
there.
you say, Mr. Manta?
No, in fact, this is a closed chapter, Your Lordship, because they have shifted to some other places.
Not shifted,
They
my
are
lord.
not sub-leasing.
How can they live
We
there
are
when there is no
concerned with the leasing,
house?
not with the sub-leasing, Your Lordship.
So we are not sub-leasing, we are the leasing.
No. Even the legislate, Your Lordship have said it, what legislate.
Your tenants, you're occupants, you're not lessee.
No, we are not the leases.
You're not the lessee.
No,
Yes.
we are not the leases. We are the tenant under this. But we are not outsiders or encroachers as my landlord friend has submitted it.
You read the report, correct?
Yes, my lord.
What do you see on this regarding these 7 names?
They are not the name, all the names are not the petitioner's name, my lord.
This name, only one, Vinod Kumar Rai. the
Only
name
3 of
exists
them
in
are petitions, my lord.
In this Santosh Devi Goenka's list as
Serial
number
number
14.
14.
Another one, Bhima Chhetri, is 16. The others who present there, their names don't appear there in the list of. Yes,
My lord, 5, 6, 7 name
My
are
lord,
petitioners.
to whom they have spoken to, we have no idea, my lords. At what time they have arrived, we have no idea. Only they have asked for list of tenants that I have submitted. I have complied with the order, my lords. They may come in the evening time, they may go in the morning time, your lordship. We have no idea of such.
Who's appearing?
On the last occasion,
Who's appearing for Om Prakash Goenka?
I appear on behalf of
You say they all left.
Lordship, and the report is conclusive, Lordship. It's from my instruction, Lordship.
It is?
It is okay, Lordship. The
Conclusive.
report submitted by
a proper verification is required, your lordship, because out there, there are
2 leaseholders say it's fine.
Sir,
One, and your only leaseholder says nothing.
my lordship, your lordship, why I am saying is this, because I am the only affected person. They are already having more than 30, 40 houses out there. It's not that I am the only one.
Their house still existing.
Still existing. So they have not gone affected. Only I am the affected person. And the list which I have given now on last occasion is not the list which I have given newly. On the last many occasion for the 3-4 years, every 3 years I have to submit the list of tenants to the cantonment board. They may verify from their office
Is
itself.
it there in the
These are
records?
the records there.
Is there in the records here?
Yes.
There is occupants of as per records.
No, we tell lazy, we don't have any record. Record lazies cannot be. Only the lazies are there, but the tenants not.
Is there, your lordship? I myself has submitted those list of tenants.
Now, now what about this, your other sheet where they are, I'll just flag it, just have a look at it.
No, only 5 Small
This
space.
is the earlier report.
Triple.
Just with the, just see. You can have a look at it. You can allow the council to take a look at it. This flag in green. Okay, here. Let them examine the records also.
Yes.
See the flag in green, the last one, regarding the which inspection was done on February 11th. Absolutely.
Supporting on 13 February 2026.
And see the names annexed to the chart. The chart
I have
by your,
this.
is by
Sanjay
your
Kumar
CEO only.
Gaika.
This I
These
have.
are the affected families.
No, this list is
are
appended
the
to your
families.
report only.
This is Sanjay Kumar Gaika.
No, this see, it is a letter of that CEO, correct? And he says the
Yes.
list is appended. So what list is this?
This is the verified list, Your Lordship, and it is verified by the police officer, the disasters management, the CO officer. Jointly, they have verified
The
this.
letter itself it says that the police.
No, you kindly see.
Yes, the list is there. It is of 31 or.
Total number is 31.
Two here.
What is that list, Mr. Manta?
List those who were found there.
Just after the incident of the fire.
31 persons were found on that day. And now they say there is.
They have collected the documents also.
Okay, we have heard you.
Immediately they instructed this. The photo. It shows.
No, yes, no. The thing that
The list of
whose names are those people?
affected families identified
who
on
are
10
those
to
people?
2026. Just after the fire.
Then those are the people that should be allowed to
Yes,
raise separate
they were
structures.
present. Therefore, their name were appeared here. But they all left.
The only thing is that they've left.
Left.
The 31 have left.
That is
They left.
position lordship.
You kindly generate a name of that list and you present it to the
They all
court
left,
on Monday.
and all this time,
On Monday.
many has been removed by them.
You just make a list of those names. We just take out my records and append it, and we'll take it up again. If this matter, disputed facts, we can't carry
All
on.
right, then I'll sort it out.
Just check your records, yes. The records have been produced today by the learned Senior Counsel on behalf of the Cantonment Board. Perusal of the same shows that in the date of the inspection, very few occupants were available and stuff. However, it is noted that in the earlier inspection conducted on this February, when the 11th of February 2026, a list of 31 occupants has been annexed there. Learned Senior Counsel, on this observation of the court, has submitted that the person recorded therein has since left the premises.
Just after the fire.
Yes, and submission supported by Mr. S. Chanda, appearing for respondents number
7 and 8.
7 and 8. Yes, be that as it may, let this, you can't be, this matter, you should suggest, otherwise, let this matter appear for 1 week. Yes, a list of the 31% be supplied to the court in a type form. Yes. Now we'll see whether 16 of your people are there or not in that list.
Yes.
Yes.
On which date?
List after 1 week. Yes. Just type it out.
Yes, I'll just.
And we'll see whether these people are there or not.
Right.
Yes.
59.
Others have left, so no. Only question is your 16 people.
No, 7 and 8, they said all left.
Certainly, they all left.
That's-
But now,
but only we
16
did on the
people-
6.
insisting on 16 people, we can't go even on the ground. But then we just see from the records.
Yes, I'll walk.
Just the list, yes.
Much.
59, my lord, I'm supposed to file a rejoinder for the petitioner, my lord. Here, my lord, I'm seeking for some more time, my lord.
How many times you sought?
I have not. I have This is the sought first in- time, my lord. I have filed in
Okay,
this period.
MSS now say it responds up to weeks time to file the joinder. Just thereafter. Also.
60.
For 60, my lord, I have just received the rejoinder. I have just received the affidavit of the state.
No, Your Lordship, we filed 2 weeks back.
But there was a mistake, my lord. There was
No, Your
some.
Lordship.
Miss Associate submits that she has just received copy of the affidavit filed with the respondents. She pays 1 or 2 weeks time to file the joinder if necessary. Yes.
Obliged, my lord.
Obliged, Lordship.
61.
May it please Your Lordship, I pray for a week's time to file our affidavit, Your
When is
Lordship.
this matter filed?
Your Lordship, on the 18th of February 2026, Your Lordship. This is the 5th time they have asked for time to file affidavit, Your Lordship.
What's the matter about?
It's recruitment under sports quota, Your Lordship.
Sports quota?
Yes, Your
What
Lordship.
happened? Why was it denied?
Your Lordship, on the first detailed medical report, I was declared unfit, but I went for the review medical report. I was declared fit, and
Dr. Mozika, why no instructions here? This is a different matter. It's not your remuneration or your.
Well, instructions have come. We placed also, but we thought we'll file now by affidavit.
So why after not filed? What instructions have you received? Review medical report. You found fit.
Now,
Yes,
it's
Your
not a question of medical fitness, my lord. She is low in the.
The question of vacancy.
She is at number 5, my lord, in the merit list.
How many vacancies are there?
Only one.
3. In the advertisement, Your Lordship, it was reflected as 3 vacancies, Your Lordship.
But you're number 5.
We have not received the merit list, Your Lordship.
The merit rankings is number 5, my lord.
Then you can you why
You will
why
file
you
it.
file it? Give you 1 week's time. Yes,
Yes,
sir. The learned DH has given 1 week's time as a final opportunity to file affidavit in the matter. Expect the next day the after to be on board. Yes.
Much obliged, Your Lordship.
62.
I've obtained the necessary NOC from court, my lord. File an affidavit also to bring it on record.
You close it.
Yeah, my lord. Only direction may be given, my lord.
Yes.
My lord, the department, the instructor is just to say short of 3 days time, my lord. They might have to say something.
Though Mr. KTH Gautam submitted that the requisite NOC has been obtained from the concerned court, Dr. N. Mozika prays for 3 days time to allow to obtain final instructions. Just after 3 days, yes. This next week, yes.
Obliged.
63.
May it please Your Lordship, the respondent are supposed to place their objection or can you offer affidavit?
We have computed the amount of subsistence allowance. My friend is carrying a calculation, my lord. By virtue of the last order, my lord, we were directed to my lord, calculate the amount of subsistence allowance, my lord. That is there. It is close to, my lord, 8,20,000 rupees.
So you've been suspended since 23?
23, yes, March 23.
Never paid 1 rupee also?
No.
When will you pay it? Within?
It will take 4 weeks, my lord's time. And my lord, the disciplinary proceedings, I have taken instructions also on the my lord's final stage. So that will also be disposed of, and this allowance will also be paid.
Yes, sir. Mr. E.S. Pandey has produced the computation of the substance allowance payable to the petitioner, which comes from amount of rupees 8,20,000 for 8,20,004. It further submits that the department proceedings are also at the
Final stage.
Final stage, and the same will be completed very soon. He undertakes that the entire amount also will be cleared within a period of 3 weeks from the date of this order. Yes. Just after.
Allow us plus 4 weeks, otherwise, my lord, there will be contempt.
Okay, 4 weeks since you waited from 23. How are you surviving?
That's what with children.
How are you surviving?
Five children.
How are you surviving then?
I went to agriculture, right? I'm doing agriculture. That's what I'm doing now.
It will be clear.
Yes, otherwise we. Yeah.
64.
I leave right to that.
But the payment has already been made, my lord.
You receive a payment?
Yes, my lord. We have received allowances from July till date. But my lord, he was suspended on the 31st of July. So officially he is supposed to get his salary, full salary in the month of July. Last year's July. He was suspended on 31st of July 2025.
In the prayer, my lord, they have only prayed for the subsistence allowance that has been paid.
Yes. We pay subsistence allowance. Let's see. Where have you written that's been cleared?
My lord, we have submitted.
This one.
Yes.
Because it took some time because different for clarification from our office because it is been cleared now.
Yes, sir. Mr. Nsinkon Leonard, GA, as per his communication dated 18 June 2026, which indicates that the authority for payment subsistence allowance has since sanctioned, since authorized the release of the subsistence allowance to the writ petitioner. Stop. On this count, the prayer request is met. What's your name? Sorry?
Kedip.
However, Mr. Kedip has submitted that issue that remains is you're asking from 31/7 only. You're not asking for things.
Yes, my lord. Yes, my lord.
You have received this?
My lord, we have received the payment slip. We have received that.
Mr. Kedip, then company also submitted that the payment slip has been received. But praise that we allowed. We won't write that. It's up to you because the action is still there. Yes, accordingly, matter stands closed. Yes, copy of the communication the 18 June 2026 is taken on board, made part of the report. So, our affidavits have been filed. Yes. It was stopped. MS. Okay, no need for that. Yes.
Lordship, I will confirm everything has been cleared, Your Lordship.
Yes, Mr. Vipasa has also placed an affidavit and submits that all the dues have been cleared. Yes, after the accordingly matters are closed. Yes.
Much obliged.
65.
May it please your Lordship. Lordship, we need some more time in this matter to file the affidavit. 2 weeks time can be allowed.
Why? What's the matter about, Mr.
Termination of cancellation of the contract, Your Lordship.
You did some amount of work?
Yes, Lordship.
For construction degree college at Chalkpot?
Yes, Lordship.
Construction is complete?
It's not yet complete. Not yet completed, Your Lordship.
Money all over?
No, Lordship. It's paid. Some money has been paid to him. There is a time stipulation that has not.
But now the thing the work undergoing by someone else.
No,
By someone else.
It has not been awarded to anyone.
Abandoned.
No, Your Lordship.
It's been abandoned.
No, Your Lordship.
Then final order issue 23. Shift time complete 18 months.
Yes, Lordship, but the first DPR was issued to us only 9 months after the work order was issued, Lordship.
You filed within 2 weeks, Mr.
Lordship, yes.
Yes, sir. As prayed for the 2 weeks time of affidavit.
Thank you, Lordship.
66. 66.
This was connected with 47 to 50.
Lordship, item 66 is connected to those 47, 48, 49, 50, Your Lordship.
Apply, Your Lordship.
This together with so. Affidavit, this is a teacher matter.
Lordship, yes.
Copy affidavit to be served upon the counsel for the petitioner.
We'll serve Lordship.
67.
Wait, please, my lord. My lord, we need further time, my lord, for filing of the affidavit.
What's the matter about Mr. Pastor?
We're seeking similar relief, Your Lordship, with previous petitioners which have approached before this court, Your Lordship.
Paramedical,
The technicians, Your
physicians.
Lordship. Paramedic.
Paramedics.
No.
Any? Yes.
This is connected to which matter?
Those paramedic technicians, Your Lordship, which Your Lordship have already decided, Your Lordship. These are similar situated.
Decided where?
This WPC 318 of 2025.
Judgments here?
Yes, Your Lordship.
This identical covered case?
Yes, Your Lordship. The only difference is they were regularized later.
My lord, we'll need further time, my lord. We'll have to look into the case.
Okay. Yes. Mr. Pasantev submits that the instant case covered by another judgment of court passed WBC number 318/2025. So, however, MS Engineer Shilla is going to place for further time to obtain or to file affidavit.
Further instructions also, my lord.
Yes.
My lord.
Please hold this up to 2 weeks. Yes.
Much obliged, my lord.
68.
One come. When was this matter filed? Oh, it was last week.
Yes, Lordship.
The objections been filed.
Yes, Lordship. I just
I have the objection for extension of stay because according to me, the writ petition itself is not maintainable.
Why?
For the reason that the impugned order of transfer is not an order of transfer. Your Lordship will just see.
Where's the impugned order?
Page 22. Page 22. Dr. Vishnu Ram Das, General Manager, Medical and Health Service, presently attached to Corporate Office Shillong, is hereby temporarily detailed at Tato Hio Neong Hydroelectric Project, Arunachal Pradesh, for 3 months, with effect from 1/7/2026.
Yes, this is
Not
very
a-
valid ground.
It's not a transfer of.
Lordship, I may say it here, Lordship. I had filed my representation, Lordship, saying that I'm
It's not a transfer.
Lordship, but
It's not
I
a
have to
transfer
go.
per se. It's
Lordship,
just that
I have to.
you go.
No, Lordship, I may just state here, Lordship, because these, even if it is written as a temporarily detailed, Lordship. Now, in their affidavit, they said that there is an exigency, whereas in the order there is no exigency shown, Lordship. And number
Here,
one,
to
Lordship.
ensure better medical facilities
Lordship,
at
if
Tato
Lordship
here.
will please allow me, Lordship. Lordship, I am a type 2 diabetic patient and a having hypertension, and I'm surviving on an insulin for 3 times a day, Lordship.
You're a doctor.
Yes, Lordship, but posting me to this place, Lordship, there are 3 different locations. They are 3 different locations. It is a transfer only, Lordship, even if it's a temporary, but it is a transfer where I will not be able to get the medical facilities in that areas, Lordship, and there are 2 different locations. These projects are.
Is the petitioner present in court today?
No, Lordship. And Lordship, my representation also till date also has not been
You'll not come
considered.
across a policy, it's not a transfer.
Lordship, but if at least consider my representation, Lordship, and also, Lordship, from the day that I have joined, I have been transferred in different locations, Lordship. I had been serving. That is there only in next page, Lordship, 23. I had been from the day of my joining, August 1994. I was in Ranagandi, Arunachal Pradesh, 14 years. Then in Assam, I was for 2 years, 8 months. Then again, I went back to Arunachal Pradesh for 2 years, 9 months. Next page, Lordship. Then in Tripura for 4 years and 9 months. Then in Mizoram, 5 years, 6 months. Then again in Meghalaya, I'm only for 2 years.
You strike out by media. 3 months you're transferring him. Just make it half of 3 months. How much? How many weeks? Half of 3 months is 1.5 months is
But
6 weeks.
Already,
Send him
due
for
to
6
the
weeks.
intervention
6
of
weeks
the,
and they'll.
due to the intervention of this court.
We're not entertaining this. Sorry. Yes.
Lordship, but I'm suffering, Lordship. At least at the moment, at least consider my
Everybody
and the
has
fact
diabetes.
and Lordship. I
Everybody
have
has
just 9
hypertension.
months. I just have
Everyone,
9 months only,
even a
Lordship.
child of 5 years have got a diabetes.
See, anyway,
And
this order is not anyway.
but Lordship, again, interestingly, they bring another doctor who's much junior to me to look into here. It is
You have
written
more,
here
you have more
only.
experience. That's why you have to go there.
But Lordship, I am
Yes,
in
it
not
can
that
be
situation,
made out of the
Lordship.
order itself.
Allow
You
me
won't- you
only
won't-
to file, Lordship, the rejoinder, Lordship.
No rejoinder. Not necessary. Take down this. This writ petition is directed against an impugned transfer order dated 22/6/2026. Issued by the respondent, whereby the petitioner has been temporarily detailed at other locations in Arunachal Pradesh for 3 months with effect from 1/7/2026. In connection with work related to medical and health services stopped. Next paragraph. The transfer is resisted as submitted by the counsel to the petitioner on the ground that
He's a type 2 number one is a
that the petitioner is a type 2
diabetic patient and hyper.
And also suffering from hypertension.
He is surviving and
yes, and is dependent on and is insulin dependent.
Fully
Further
dependent.
ground is that the representation file has not been answered.
Has not been answered
The
today.
representation file against the transfer order has not been answered. And third was the other ground.
Lordship, the other one is also Lordship because they are saying that this policy is not it's not statutory and mandatory, but
The third,
but they are relying in these clauses.
Third contention is that the transfer policy or guidelines of the NIPCO have not been followed in the in consideration to followed with regard to the legit transfer of the petitioner. The council therefore prays that the impugned order, the impugned transfer order be interfered with, considering the fact that the petitioner has the 9 months of service
left.
Mr. Vikijan, the senior counsel.
Your Lordship, I'll just say
to
subpara 1, 2, 3, 4 of para 5, my grounds.
Yes.
Subpara 1, 2, 3,
The
4
affidavit.
of para 5 of my affidavit.
The Mr. Vikijan, learned counsel for the respondent reply. My affidavit.
This case.
Affidavit. Where's the affidavit?
It's already filed yesterday.
Where is it? It's not on record.
We already filed, sir. Just I'll give it my copy.
Yes. For today, right, this is matter together with the main case tomorrow. This is Miss Case 195, and this is matter with the main case tomorrow. That will be 295. Yes. We'll dispose of tomorrow. Yes.
69.
Pledge. This file, no? Where it is gone? They have to file affidavit.
But we'll need some more time to file an affidavit.
1 or 2, huh?
Yes. Why? When is the matter?
This is the first date document.
Oh yes.
Oh,
As paid for the 2 weeks time allowed for affidavit. Yes.
Apply, Lordship.
State no affidavit.
State will also seek instruction, Your Lordship.
As paid by the respondents for the 2 weeks time allowed.
Apply.
Slash instructions. Yes.
70.
I'm getting you. Yes. We've taken steps.
Lordship, in terms of your Lordship's last order, we have taken steps, Lordship.
Yes, office note indicates that service on respondent 5 and to 7 is not yet complete. Yes. Yes. What do you have to say? Affidavit, how long?
Lordship, we actually have a report that has been submitted by the OC Khanapara, my lord.
What's the matter about?
Lordship, this matter pertains to defreezing of my account, Lordship, personal account.
Oh.
My lord, we can place the same when the banks come forward, my lord.
Yes, sir.
Lordship.
Let them bring it by way of an affidavit, Lordship.
No, Lordship, we won't bring it by way of an affidavit.
NG Shilla submits that no instructions have been received. It would be more appropriate if the same are presented when the banks, when the concerned bank, that is 5, 6, and 7, appointed the parents of Ms. S. Chanda permitted to obtain status of service
And file affidavit.
set respondents.
Much obliged, my lord.
After 2 weeks.
71.
May it please your lordship. Lordship, in terms of the last order, my lord, the respondent number 4, you have to file the affidavit, my lord.
Who's for number 4?
This is Mintri of Sankor Khavikor, my lord.
Yes. Number 4. Mr. Spindram, where is he? What's your name? No, your name. Yes. No, your title. M. Dingdo. Okay. Yes, and number 2. Mr. M. Dingdo, Vice.
Yeah, this is a formal party, Lordship.
First one before not filing. Please allowed how much time? 2 weeks time. 2 weeks for the time to file affidavit. The phrase allows of Mr. S. A. Sheikh on behalf of the state respondents. Number 1 and MSP somebody for 2 submit no affidavit forthcoming from these respondents. This of 2 weeks.
My lord, if I may place one small submission, my lord. This writ petition number 183 of 2025 are connected, my lord. If it can be, can come on.
Let them complete the pleadings first.
Lord, oblige, my lord.
Yes. You call out this.
Hearing. 73.
Hmm? 78. Okay. Connected.
No, sir.
The qualification was vehicle mechanic. 73 and 74 are connected, Lordship.
Right.
Affidavit.
You got the rules?
Yes, ma'am.
So what do you have to say, Mr. Pandey?
Lordship,
You've seen the rules.
There's just not the protocol. Can we take them tomorrow? In terms of
Dr. Nvozika today has produced the rules governing different rates. As allowed by Order 23/6/2026. A copy of the same is supplied to the court and also to be filed or to be presented to the court as well to the petitioner. It's just after 1 week for further hearing. Isn't the hearing stage correct?
Lordship.
74.
Connected matters.
78.
You gave him a copy of the rules.
Yes. Make copies good. That works.
Lordship. Lordship, on the last occasion I have filed the additional affidavit to bring on record that I have been twice regularized in the same month as a work charge. In the additional
Twice regularized in the same month, regularized twice?
Yes, yes, my lord.
How is that possible?
Yes, it's a government done by the executive engineer PWD, my lord. May I just admit?
Where's
the work charge position, my lord?
That is in my additional affidavit.
Who? Yes.
In the additional affidavit, my lord. I filed on June 2020. Last there was June 1st June 2026.
Okay.
It is a relevant page, my lord. It is a page 7 and then page 9. This page 7 is a type copy. Original copy also is there. Page 7.
99 observed work charge, right? Next.
Yes. Next is on 27/5 this 1999.
Yes.
Page 9.
Page 7, 1999, and
Yes.
then page 9.
Yes, that is on date is on 27/5/1999. Again, obvious as a
One
peon.
by
Hereby.
executive engineer and
Yes.
one by SDO.
Yes. So,
are you retired now?
Now I am retired, my lord. Now thereafter again, my
you
lord.
allowed a regular scale.
Yes, I was allowed by regular scale. I was doing the salary of the regular scale of the sectional
Against
assistant.
what post? Offer?
Now actually I was
What? Oh, section
assistant.
Oh.
I was promoted by the DPC, my lord. The page
and MS Ain's case is that you never regularized by incompetent authority.
No, my lord, that's not my case. In fact, these
Then-
documents are completely unnecessary.
No, lordship, may I just submit?
Let
me complete now. Yes, let me just submit now. The departmental promotion, as far as the departmental promotion, how the procedure has been followed during the departmental proceeding. During the departmental proceeding, what happened actually? They will see the ACR. That means that the annual confidential report. All those things will be prepared by the department head of the department, and then they while preparing the ACR and also the department, they also see whether there is a vacant post or not, whether there is seniority or all those things.
Where are you going? What is your right?
Yes, lordship. Now what in the case is now I was promoted to the sectional assistant. Now they are reverting back to the peon, stating that that I was promoted on the basis of the draft, which is improper.
Oh,
that is the thing.
Your last pay will be for peon.
Yes.
But were you regularized as peon only? What is the case?
Now I was regularized work charge as a peon twice. I was regularized, and also department. Then now they after that I was promoted by the departmental promotion committee. Departmental promotion committee. That's why I'm trying to explain, my lord. What just kindly have a bear with me. Just a departmental procedure is the head of the department will prepare.
One thing, Mr. Sangma, if your promotions have been irregular, not by due process.
Yes.
And so if substantive posts that are peon, as that's the case, I think. So
no one
you've enjoyed your
lordship
for how many years? Since 99.
9 years.
99. You retired when?
Retired. I retired on the. Where's my retirement? I retired on 21 5/2021.
21. Okay, from 99 to 21, you enjoyed the post of section assistant, correct? So you were regularly promoted. Okay.
Yes.
And so and then now they're fixing a pension on a scale of peon.
No.
What to do?
No, Lordship. That no. My argument is, Lordship. In the annexure 4/18, page 18, annex enclosed by the affidavit in opposition by the state respondent. They have stated that I was revert back this one because that draft memo was improper. That is the only thing. The draft memo.
Oh, you see this? See the affidavit of the.
Yes, page 18. Page 18.
You enjoyed 9 years.
No, Lordship.
And then rejected later on when your matter for graduation came up. They dictated and so.
No, Lordship, may I submit your my answer.
Is the court stopping you submitting?
Lordship, no, Lordship. Just bear with me. I just wanted to make a submission regarding the annexure that page 18, the annexure 4. Now, when any service rule or any draft memo or any notification is denotified or it is withdrawn or is cancelled, then the government usually practice or use the procedure. When any government rule or any notification, when government
withdraws what?
Withdraw the notification.
Which notification?
Notification means they are saying the draft memo. They said that because they are saying that I was promoted on the basis of the draft memo.
Yes.
Draft memo on the draft memo is mentioned here. Draft memo of the dated the draft memo number PRACR 60/999 dated 26 July 1999. They said this, I was promoted on the basis of this draft memo. Now they are saying, their argument is saying, since this draft memo is improper, that is the only explanation. Therefore, my promotion was irregular. Therefore, from sectional assistant, they have reverted back me to the peon. Therefore, my reply to their answer, they have only stated that since this draft memo is improper. Now, that's why my argument is, when any service or this draft memo, if the government withdraw certain notification or memorandum or service rule, they usually issue notice to the affected person. Prior to cancellation, they will issue. Now, in this particular case, since I am affected person, since I was promoted on the basis of this rule, I was not notice. No notice was served to me. And secondly, my lord,
just one question. So you reverted in which year?
Reverted which year? That also.
You promoted in 99.
Yes.
That means you said 9
after
years.
retirement only.
9 years you enjoyed as 9 years you enjoyed as a section assistant, correct?
Yes.
So 99 plus 9, how much?
99 plus 9.
2008.
Yes.
So were you aware in 2008 that your reversion had come and you were put back for the peon? You're not aware?
No, I was not.
Continued to work as section assistant?
Yes, only after retirement. Only after retirement I came to know that my service was reverted back.
The pay you getting of section assistant only?
Getting only since from my promotion till my retirement. And I come to know that my service was reverted back to the peon only after retirement. Government have issued certain order, that is see, my lord, after retirement here they have stated page 21 of their affidavit, they have issued the letter dated August 2024. That also I retired in the year of 2021. Till then still I was not aware of my service was reverted back. Only after 3-4 years of my retirement they have stated and communicating that my service was reverted back to the peon, and my regularization as a sectional assistant was not considered. That is the case. So this is the clear violation of rules, and then it's a fundamental principle of principle of natural justice. I was never informed. Neither they have issued any so-called notice, and there is no any circular or any genuine reason why the draft service has been recalled. They have not denotified officially. There is no letter showing that draft rule, which they are alleging that is improper, has been officially denotified. There is no letter. They only stated in that draft memo is improper. How it is improper?
Where are you getting that from?
Yes. That is in there. Page 18 of the affidavit in opposition filed by the state respondent, Annex Chart 4. They have mentioned. The only one line, the relevant line, is the para 2. I will just read it for you.
You don't refer to any memorandum.
Yeah. They only says.
Yes. It may be noted the government regrets.
No. Sorry, Lordship. There's one more. I'm sorry, Lordship. There's one more. Where is it? Not there. Not this one, Lordship. I'm sorry. This is my petition. No, Lordship, it is there. I'm sorry, Lordship, I have sorry to the wrong provision there.
One thing,
page 8, my lord. Page 8.
One second, one question. Is there provision for promotion from peon to section assistant?
No, my lord. Even under the draft rules, there was no such provision, because that's a technical post, and peon comes under ministerial post.
If they say even if the draft rule is not, then why they should have mentioned that draft?
Why is improper things that they've committed a wrong? So even if we allow you, that means two wrongs don't make a right. You want to hold them accountable for allowing you. Now you enjoyed. If you see, in 19 days,
and then
you enjoyed the scale, so it's fine. It balances
they have not produced any resolution.
Don't need to put resolution. Draft rules don't need to be recalled, in the sense that they have not been implemented at all. The draft rule will not have no effect on you. What page 8? What page?
Yes, page 8. They have mentioned page 8. Yes. Page 8, Annex 1.
Yes.
With reference to subject server, I am to inform you that the service book, part 1 and part 2, in respect of Sri Mohindra G. Mohan.
Where's the draft office memorandum?
And now,
next it. A copy of that.
They have supplied the
in the affidavit.
No, they don't enclose in the affidavit. They just give it.
Wait.
My lord,
yes, MS.
I think this is the.
My lord, we have produced it. My lord, you would have it on record. It's not with an affidavit. We produced it on a later date.
I think this one they have produced.
It's a very old draft.
Where is this one?
Rules, my lord, which never saw the light of the day.
This one. This one. They just give it without filing the affidavit.
Yeah.
Dated 26 July 1990.
Yes, got it. Yes. Which provision did he rely upon to grant him promotion? From the draft service rules? Unknown.
No specific.
They see, come to head assistant, upper division assistant.
Here also they, of course, they don't mention this which provision is supplement. The head assistant.
Ministerial district establishment service rules. So the
upper division
SA is a technical.
Division assistant.
So the
division
assistant
lower division assistant.
There's no schedule here. Schedule only head assistant, upper division assistant, lower division.
Lower division
and then
assistant.
you don't pick out those rules also. You're not covered by the draft rules also. Doesn't mention peon.
That's right.
The schedule only head assistant, UDA and LDA. Then
yes, it is, Lordship. My humble submission, it is not. It is done by the department. They quoted this rule, but of course, even in this, neither it is not from this rule.
One thing, you take instructions from your client, say that.
Madam, we have been sending them reminders to complete the process.
Complete the process.
To give them
you tell your client that you'll have to, your pension will be fixed from the scale of peon. because the entire, you enjoyed enough, we did not seeking recovery of the amount, seeking recovery of the amount that have been given to him, of the excess payment.
My lord, we are saying
Then,
we are ready to treat
see,
it as
be
official
happy that,
premises. That's
see,
what
if
we
you really promote it, they can seek recovery of the amount they paid to you also. You take instructions, or you'll close the matter. Yes. Any other matters?
Grateful.
Any other hearing ready to be taken up?
79.
Otherwise, we'll rise now because the court got to leave also. Yes. 71?
Much less lordship.
71 who mentioned for consent? 79. Yes.
Victim mentioned, but I pray for 3 week time lordship. Our senior conducting counsel is not feeling well.
Who's not feeling well?
Senior conducting person, Mr. Sen.
Mr.
Sen.
SN?
Yes.
No objection, Your Lord.
Interim order. There's interim order. Interim order. Interim order.
Is there?
Yes.
Nongjorong village?
Yes.
Interim order to continue, yes. Yes, after 2 weeks.
80.
Much obliged. Please, my lords. Once in the last day of hearing, this Honorable Court has decided that equal proportion of the gratuity amount shall not be granted to the respondent and appellant. My
Yes,
lords.
respondent.
Yes, Your Lordship.
What instructions have you received?
Instruction only received, Your Lordship. It is only the discretion of the court. We are leaving to the
What discretion of the court for?
court for settlement only.
Settlement,
The ratio-
settlement amount.
It is already settled by 50-50. So, Your Lordship.
Then make it 50-50.
My lords, I'm the legally wedded wife of the deceased, my lords.
No, that's what I'm just
So only for
in
record.
jest.
Only for record. This is. But thing is that
No, last observation of
Later-
how much, what percentage, how much?
Last, you've given 40%, my lords, and we are not really satisfied. So, since they have 2 children, so we're settling for 20%. They have 2
20%?
20% is enough, man.
because
2 lakhs,
expansion.
2 lakhs enough, man.
Your Lordship, if go by the evidence only, because she is totally not represented her husband. Never she was in the side of the
That
husband.
doesn't matter. The first claim is always the legally
And
wedded
she
wife.
will enjoy the family
Family
pension.
pension, she'll enjoy. She'll
Yes,
give you
yes.
2 lakh. How much you'll pay?
She will enjoy.
2 lakhs, my lords.
She will enjoy
Out of
the.
the nine-
How old are the children now?
One is
attain the age of
one is
majority.
16 or something. Birth
They all
certificate.
attain the age of majority, my lords.
No.
Do one thing, be patient. We'll take it up after 3 days. 3 days is not on Friday, we take on 15th. We'll dispose it off. Just 22 lakhs. Yes. Keep that in mind.
It won't be justified, Your Honor, please.
Can't help it.
Because she has spent a lot of money for the. Yeah.
Okay, you try to convince the court again, but yes.
Obliged.